Please, motions, please give the slip.
Yes, Lord.
Hearing, please give the ground of urgency and give the slip.
Lord, similar type of matter, my Lord, disposed by this coordinate bench, my Lord. So, 2017, my Lord, primary bench.
The hearing. Hearing.
Hearing, you have mentioned the
Yes, my
urgency.
Lord. Yes, motion.
Motions give. And please write whether motion or hearing. What is the application for? Restoration. You have written restoration. Take. Please write what it is for. Please write and give, otherwise it becomes difficult. Call করুন দিদি, call করুন.
I'm appearing for the state. Let it be passed over, my lord.
Pass over করে রাখুন.
This is my application.
State. You are appearing for the state.
No, I beg to appear for the private respondent.
Pass over করে রাখুন.
Or then not to.
Why not today? Wait.
Lord,
If you are not there, it will be called on in the second call. I'll then make it not.
Okay, man.
Lord, I have some personal difficulties. Because
For
I
what?
have to go, my Lord. Item number 3 is there at code number 2.
So I have passed it over. If you are not there, I will not take. I have said so. Why do you want not today in every matter?
I'm item number 1.
You are there, your other side is there.
Yes.
চলুন কল করুন পরেরটা. পাস ওভার করে যান. চলুন.
6 I am for the 5 I am for the 4 5 I am similar matter.
Both sides are not there, so it will not be possible to take. Let both sides come. Let people come. I am passing it over.
6 I am for the petition.
Your other side is not there. Pass over করে যান. Call করুন একটু. Please wait. 74 is long back. We are on 7. Item 7. Call করুন. Passed over. Passed over. Passed over. Passed over. Passed over. Passed over.
I'm for the petitioner, Lordship. I'm praying for 1 week adjournment, Lordship.
Why?
Advocate Shankarnath Mukherjee is not present today. He's not well, Lordship.
Item 12.
12 and 13, Lordship.
12 and 13 both. 12 or 13?
12, Lordship. 12.
Not today.
Not this week, Lordship.
ঠিক আছে 12 not this week করে not today করে রাখুন, not this week হয়ে যাবে এমনি. not today করে রাখুন. If tomorrow you have difficulty, you come and mention.
Okay, Lordship.
Not today করে রাখুন. Next.
13 I am for the petition.
Passed over.
My lord, I am for the petitioner 14, my lord.
Yes.
My lord, I am praying for not today, my lord, because my lord,
Not today.
delivery service not prepared, my lord.
Not today. Not today.
Oblige you, lordship.
চলুন 15. Passed over. Passed over. Passed over. Passed over. Passed over. Passed over.
21, I am for the petitioner.
পাস ওভার করে রাখুন, চলুন চলুন চলুন, দাঁড়াবেন না, কেউ নেই, এক পক্ষ নেই যখন ফালতু দাঁড়াবেন না। Fast over. Other side is not there. Please wait. Let both sides come.
Twenty-eight, Lordship, I appear for the petitioner in this matter. Lordship will recall that the other day, Lordship has substantially heard this matter. Mr. Jishnu Shah was leading arguments and Mr. Tiwari was there on the other side. This is regarding.
They are not there. Let them come. The other side is not here.
There is some urgency, Lordship. So.
So I cannot pass an ex parte
So I
order. Let
understand,
them
Lordship.
come.
So I was praying if Lordship will be pleased to fix the matter at some time today. I can inform Mr. Tiwari to be present.
I'll finish this list. Come back to the Passover matters. It will be called on. Don't worry. No
Very well,
fixing now.
Lordship.
No
Much
fixing of time.
Much
Call Koru. কল করুন, দাঁড়িয়ে যাচ্ছেন কেন? কেউ না থাকলে কল করুন, বারবার একই জিনিস বলতে।
32, I am for the petitioner.
I'm for the respondent.
Since both sides are not there, it will be useless hearing one side.
I will have, but on the other day, Union of India appeared. Now, your also directed me to serve the restaurant of five. I served him, but he is appearing for the restaurant of five.
Very well.
Both the, all the parties come.
কল করে যান, কেউ নেই তো সব পক্ষ। এবার পাসওভার ম্যাটার গুলো কল করছি। Yes. One. So when will he come? Yes, Dick, I'll.
I'll have take the short Passover.
Again Passover. 10:38 now.
April, Mr. Bhuvishwas is happy.
What is the matter? Let
Man,
him
this
start,
is-
let him come.
This is regarding the imposition of, my client applied for counter signature.
Applied for
Counter signature, he's a permanent
Interstate.
on the interstate, my lord. His permit initially was issued in 2006. Thereafter, my lord, it was not continued. My lord, because of disturbance in between them, my lord. My lord, thereafter, my lord, the permit has been countersigned, issued by the STA Bihar in, my lord, your lordship kindly come, page 24,
page 24.
my lord. This is
Yes.
governed by interstate permit, my lord. Interstate reciprocal transport agreement.
Yes.
My lord, your lordship kindly see, permit has been issued, my lord, in the column number 12, my lord, if your lordship kindly see.
Page 24. Yes.
Page
5
24.
years with effect
Maximum
from.
period permit, 5 years with effect from 1/2/2021. My client applied for counter signature before the State Transport of West Bengal. And with the prayer for deposit of tax. That was not considered. STA Bihar also, your lordship kindly see, page number 2, my lord. Annexure P2. Permit with counter signature, permit, timetable, everything was issued, my lord. Page 27, Annexure P2. The Secretary STA Bihar also requested the Secretary State Transport of West Bengal to endorse counter signature on the permit.
Yes.
Your lordship got it, my lord. Then, my lord, thereafter, my lord, my client deposited the permit as well as the my lord, request for endorsement of counter signature. That is page 28.
Page 28.
This is a representation applied for, my client applied for endorsement of counter signature. the matter was kept pending. Thereafter, Secretary ST Bihar again requested the Secretary ST West Bengal, and it's a P4 page 29.
Yes.
In the middle portion, if you also kindly say why there was a delay, delay has been explained. Due to dispute of tax due with regard to another vehicle of the permit holder's son, the matter was delayed due to pendency of the tax appeal number 01/2014 before the department, and since in the aforesaid appeal, realization of due tax has been stayed, therefore the subjected permit has been renewed with condition the result of such tax appeal number 01/2014 will follow regarding liability of payment of tax with another vehicle. That is regarding the dispute in between the permit holder and the transport department of Bihar, my lord. Thereafter, my lord, because matter is pending, my client again made a representation, page 30, and it's a P5.
Yes.
Regarding above mentioned, I have to say that the permit route of Pune to Golga is in your office for countersignature since 3 months. Computer operator of your office saying the permit is not showing online. But the computer operator of the ST Bihar Patna said to me that the above mentioned permit is showing online, and the copy online ST Bihar Patna has been attached with this application.
Yes, I've seen that. Now the order impugned is at page 39.
Yes, my lord.
They have said that there were certain taxes which were due in respect of your old vehicle, not of your son's vehicle.
My lord, my client permit has been renewed just now. In 2006, while you were lost a LDC,
No, but it says that petitioner says that he is not liable to pay any tax because he has not operated the vehicle.
Yes, my lord. Not countersigned even. Permit has unless the permit is countersigned, payment of tax
No,
does
the
not.
old vehicle which was replaced.
My lord.
There were 2 vehicles. One is old, which has been replaced by a new vehicle in respect of which you are now seeking permit. The old vehicle, in respect of the old vehicle also you have not paid taxes.
My lord, that is not the dispute here.
That is the dispute, page 39. That is what the dispute is. Your Bihar authority has said something else, I have read that. But the West Bengal authority says that petitioner has said that he is not liable to pay tax to the state of West Bengal, having not operated any stage carriage. This vehicle has been replaced. Heard submissions. It appears that he has not paid additional tax and MV tax against the old vehicle for the period as mentioned below.
That was not your loss kindly see. The permit itself, if your loss kindly see, the permit itself. Kindly see, at the top, page 24.
Page 24.
Permit Interstate 001 by 1986, WB. Right hand side, my lord.
Yes, yes, I have seen that.
That is 11th of May 2006.
Yes.
Thereafter, there is no reflection regarding the continuation of the permit. Permit has been renewed for 5 years with effect from 1st of February 2021. That is the indication there.
So this BR11C 7507 is not your vehicle?
No, my lord. That has been replaced. Your logically that is stated.
What was the earlier vehicle number? But that vehicle was there. You were flying that vehicle.
Yeah, we have logically come to page 38. Page 38.
38.
This is another letter of the ST Bihar, my lord.
Yes, that the 7507 was supposed to be replaced by BR11 7507.
Apply the countersignature replacement of vehicle number 750 by vehicle number on this permit for the route past Pune to Galgaria.
No, but for the period from 2016, you have not paid taxes. That is what it shows at page 39.
2016, there is no reflection that I had a permit.
No, your permit was till 2021. Please see. Please.
21. My lord,
But therefore 2016 is before, within 21.
my lord, it was also mentioned in the permit system, my lord, with effect of 1st of February 2021.
Yes.
But your lordship asking me whether in between 2006 and 2021,
Yes.
whether 7507 was operated and
Yes.
tax has been paid or not.
Yes.
That instruction I do not have.
Please come, because that is what
My
has
lord,
been reflected in the
lordship,
order.
right, my lord, your lordship, kindly give some time, my lord, so that I come back with instruction. My lord.
Very well. Heard learned advocate.
May I hand it over to your lordship, my lord?
You can hand over.
But we can, I think we can. Then I think that hurdle we have crossed after 22 judgment.
My lord, this is judgment justice process. Justice process, justice value process.
Justice board আসবেন, justice
আরে জানি আমি আসলে সেটা দেবো তো
ডিভিশন বেঞ্চে জজের বলেছিল তোমরা ফাইন্ড আউট।
এটা একটা ফেরত দিয়ে, একটা 2 কপি চলে এসছে, ওনাকে একটা দিন।
I have given a copy, my lord.
না এখানে 2 কপি চলে।
আচ্ছা।
Thank you. Call court. Next.
Much of price, my lord.
Madam, this is my application. madam. Yes, Dimacho.
Hmm. That's all.
Under the petition before Lord C, holder of a permanent state gas permit issued by the State Transport Authority Bihar on the route Raiganj, Purnia to Raiganj. Malab permit has been issued, permit has been countersigned by the State Transport West Bengal, malab including the timetable also. Malab. That is also a law. Malab. You also can see. Section 881.
Section 88.
881, madam. Madam, may I hand it over to madam?
No, I have.
Good instruction is your. Hey.
Yes, 88(1).
881, madam. Except as may be otherwise prescribed, a permit granted by the Regional Transport Authority of any one region shall not be valid in any other region unless the permit has been countersigned by the Regional Transport Authority of that other region, and the permit granted in any one state shall not be valid in any other state unless countersigned by the State Transport Authority of that state or by the Regional Transport Authority concerned. But there is subsisting interstate agreement between West Bengal and Bihar, my lord. Pursuant to that agreement, my lord, permit has been granted. Permit has been countersigned also. You will also section 881, my lord, you will also can see countersigned by the sister, my lord, you will also kindly see the petition, my lord. Permit as page 19.
Page
19 of the writ petition. P1, my lord.
yes.
In the middle portion, my lord, your also route details is there. Purnia to Raiganj via Dalkola. In the middle portion, there is an issue by the Secretary State Transport Authority, Bihar. Then you will also kindly come to page 21.
Yes.
The timetable is one of the conditions of the state gas permit. Timetable has been issued by the State Transport Bihar. Page 21. And annexure P2, page 22. This is the request made by the Bihar authority to the Secretary State Transport of West Bengal for endorsement of counter signature.
Yes.
Then you will also kindly come to page 23.
23.
My lord.
Yes.
This is the letter of the State Transport of West Bengal, my lord. Countersigning the permit with the approval of timetable. But during the operation of this vehicle in terms of the timetable, my lord, the local authority, the regional transport authority, my lord, Uttar Dinajpur, my lord, the restaurant of Ford has been causing disturbance to the operation of vehicle. He has been intercepting the vehicle without a reason, despite having all valid documents. For that reason, I have to come. I have been suffering. The passengers are suffering because they are not allowed to operate or to avail of the service, my lord. Then I have to come, my lord, Page 23, my lord, page 24, this is the letter written by the respondent 4 to the address to the respondent 3. He is intercepting to the operational vehicle.
The regional transport officer, Uttar Dinajpur.
Regional transport 3.
You are appearing, Mr.
He has
Debra.
no jurisdiction. In what jurisdiction do he have? Permanent permit on the interstate route is a completely different sphere. Permanent permit on the interstate route, countersigned by the state of West Bengal with the approval of timetable. I am entitled to operate my vehicle on the strength of the permit and timetable. Now the local authority is intercepting my vehicle.
And if there is any illegality on your part, then
No,
like,
no,
if suppose there is any illegality, who will take care of that?
nothing, my lord.
No, suppose there is any illegality committed, then which authority will have jurisdiction? In
But
that case,
the local authority must reach to the state of West Bengal, my lord.
and the state transport authority will then take action.
Yes, yes.
Local authority of
No,
itself cannot take action.
Section, my lord. Section 88.
Yes, sir.
I am entitled, I am praying, my lord, let me operate my vehicle peacefully.
Yes, Mr. Debra.
Yes. But I am not opposing this. Well, the only thing, my lord, saying, well, A to B, B to A. His permit was granted from Punya. Permit was granted from Punya to Raiganj by the Bihar authority. But he is operating his vehicle from Raiganj to Punya.
No.
No.
Timetable.
I am not disturbing you, Mr. Samanto.
I'm not. Don't show your face.
Sorry. I am not saying. Then, my lord, past association of the local authority, they have made an objection before the authority regarding halting or night halt at Raiganj. They are disturbing their flying. That is why they are reporting. And
What does the law say then, Mr. Debra, that you yourself can?
RTA should, RTA, at the direction of the STA, RTA should take into as consideration regarding local authority. Lordship correctly points out.
No.
Who will take care of the local authority? Local cannot be go to writers building to Raiganj, cannot be permissible. There is local authority, that is the RTA, Regional Transport Authority. They looked after the matter. That is why, my lord, the RTA, some objection has to be made and immediately wrote to the ST, intent matter, because it's a STA matter. Lordship kindly see, my lord. Lordship kindly see. My instruction, Lordship kindly see. I am only thinking, my lord, regarding he is challenging. Which portion he is challenging? It's a challenge question.
He says he is challenging the high-handedness.
High-handed. No question of high-handed. On the basis of the complaint I received, I sent to the my higher authority, who is my STA. Is the appropriate authority. What is wrong in it?
Yes, Mr.
Lord,
Samanto,
kindly
if
see,
they
madam.
have,
Madam, may I answer?
they have complained to the state transport authority.
Madam, may I answer his query?
No, if they have complained to
Madam,
the
may I answer your lordship?
Mr. Samanto, if they have complained to the state transport authority, then you will answer to the state.
No, I am not. It has not been addressed to me. It has been addressed to the state.
About him only.
Madam, your lordship, law is clear.
One
Madam,
by one. Lordship, kindly see my instruction one by one. This is the objection, annexure P3. Then, my lord, I wrote a letter to the STA West Bengal on 4th October 2024, annexure 4. Lordship, it is not resonator. Sorry, my lord, extremely sorry. My
Yes, I have got it.
lord. Annexure 4. Copy. And this is the malad. Then well, similar contention malad. Again, I wrote a letter to the STA, and this letter has been challenged. But malad, thereafter malad, it was not annexed. P6. STA wrote a letter to the STA, wrote a letter to the Bihar authority, directing to fly according to their respective route permit. But they failed to do this. What is wrong in it?
হয়েছে না হয়নি?
বলো হয়েছে শেষ করবে
মানে I am answering his query, ma'am.
entire documents before your lord.
Yes, I am answering his query, ma'am.
State Transport Authority has written to the RTO saying that they should ensure that vehicles ply in terms of the route and schedule.
I am plying. But kindly come page 23.
How writ court will
There is
now-
no dispute. Page 23, your logically page 23 of my writ petition.
Yes,
That will make clear.
page
Kindly-
23 is your timetable.
No, time. Mala, your logically see.
Page 23 is your timetable.
Timetable. What
But,
is
but
time?
their allegation is that you are not sticking to that.
No. On that basis, I am plying. Can record my statement, my lord.
Their allegation is.
Mala, your logically see. Kindly come page
How
23.
will the writ court now decide this, Mr. Samanto? You
I
are
am not-
saying
I am
one thing, you are saying something, Mr. Debraj is
No, I'm
Debra is
I'm
saying
not
something.
disturbing your logic.
It is oath versus oath. You will file an affidavit, he will also
No,
file
I
an
am
affidavit. How will I decide?
I am satisfying your logic here and now, man.
Please.
Mala, kindly come to page 23 on.
Page?
Mr. Debra, kindly allow me. Mala, page 23, your logic kindly come.
Yes.
Mala, my vehicle, mala, your logic kindly page 23. This is the countersigned permit and with the approval of timetable.
Yes.
It is departs from Pune 4:50 p.m. Mala, kindly see. Dalkhola 6:30 p.m. Raiganj 6:10 a.m. Raiganj, Dalkhola 8:15 p.m. and Pune
8:15
10 a.m. I am operating that basis.
That is your submission. His allegation is
But
something
let them
else.
say what timing I am following. Let them
Then
say
let them file a report then.
yes.
Let them file. You file a
Yes, sir.
Yes,
No,
you
no,
bring
no.
it on record by way of an affidavit. He will answer to that. The petitioner
30th.
Yes.
3 minus 3 and 4 3.
Yes, sir.
I beg to appear on the profile.
Yes, sir.
State respondent is not.
State, I am for the state, my lord, led by Mr. Sushantopal. He is coming, my.
Very well. Please proceed. What is the matter, sir?
Permit holder. In respect of group, my lord, Kalna 2, Bhavan. Kindly come to page 15.
Yes, page 15.
It is valid till 27th May 2029. There are some alignment which is in Bhaya column.
Yes.
I started to apply, but the private respondent obstructing me to apply.
Private respondent obstructing you.
Yes, ma'am.
Then, yes, why are you obstructing?
Thereafter, my lord, I made
Allegation is not proper. My lord, there are some dispute, my lord, because the timetable is not maintaining properly by them. This is the whole difficulty. They are not, my lord, nowadays, my lord, the passengers are, number of passengers, my lord, decreased. And my lord, for that reason, my lord, they do not maintain the timetable properly. That is why the, my lord, buses. my
You have
lord,
made
who
any
are
representation before the state, before the regional transport authority.
before the state
No,
transport
they have
authority.
lodged the complaint before the
State
my lord,
transport authority.
inspector is there.
My permit granting authority is state transport authority.
The permit granting authorities.
Page 21. I made
No. Who had granted the permit? State.
state
State
transport.
transport.
State transport authority. You have made a representation.
My lord.
Let him consider it. Dispose of the representation in accordance with law.
By hearing all the parties.
Yes, of course. The petitioner.
Till disposal, my lord, I can.
No,
file.
nothing till disposal. I'll only direct. Otherwise, if I direct affidavits exchange, then nothing will happen because this matter is actually a Group 9 matter. You should have
Group 9.
approached the police bench,
Which have
or I'll release it. You
In
make up your
group-
mind.
my lord,
Otherwise,
in-
I'll dispose it of
in
directing
group 7
represent.
jurisdiction, my lord. In group-
Your grievances against the police actually. Then should I release it, saying that it is a Group 9 matter, or you want consideration of representation? You make up your mind.
under appellate side rules, my lord, it is under group 7.
Your grievances, if private respondent is obstructing, it is a law and order problem.
It is obstructing on road.
So what? State
I-
transport
I-
authority is
I could not-
its only business. Its only business is to see that you are applying in terms of the timetable. If somebody comes and stops you, it is not the state transport authority's business.
Appellate side rules, my lord,
Sir, then I am releasing it. You take your turn.
my lord,
because-
kindly adjourn it. I shall show the
Show it. Not today. Bring it tomorrow. Next.
my lord, 3 and 6, my lord, similar matter. And my lord, my London friend, my lord, has filed this.
yes, my lord. Not today.
3 and 6 not today. You
Right.
show me tomorrow.
Yes.
My lord, I beg to appear on behalf of the state respondent. Item 4 and 5, my lord, both petitioner are same.
4
my
and
lord, but
5.
the number are different, my lord.
Similar.
No, my lord, I have specific instruction in item number 4, my lord. There is an allegation from the association, my lord. I have folded the page, my lord, for the convenience of your lordship, my lord.
What is that?
4, my lord.
Yes, similar to that of 2. I have directed filing of report.
My lord, I
You
will
file a
send it
report.
in the form of affidavit.
Yes.
My lord, I shall.
The respondent number, there it was 3. I don't know what is here. The Secretary, State Transport Authority.
My lord. Moreover, my lord, this is a reciprocal agreement, my lord. The STA Bihar should also be added as a party, my lord.
His allegation is against the Regional Transport Authority. I just wanted to see what is the stand of the State Transport Authority, then we shall take a call as to whether at all. ওই item number yes, I'm taking. I have already taken that on record in the earlier matter also. All of it will go. Huh? July 30. Yes. কোনো ডেট দেয়া নেই তো আগের ম্যাটারেও কোনো ডেট দেয়া ছিল না মানে ভেতরে কোনো ডেট রেফার করা নেই না না তার আগে মানে পিটিশনের রেসপেক্টে কোনো ডেট রেফার করার ছিল না বলে হ্যাঁ সেই জন্য তাহলে সেম অর্ডারটা চলে যাবে হ্যাঁ 30 তারিখ আর ওই ইয়েটা কেপ্ট অন রেকর্ড ইনস্ট্রাকশন affidavit of service same next
There is no representation from there in my lord.
কোনটা এটা?
Item 6.
Fine, fine.
5 to 5. Sorry,
No, no.
4 and 5. 5.
সে 5 ডাকো কি মনে করছো কেন? 5 ডাকো 5 ডাক হয়নি এখন।
yes
And this is also like that of 2, my lord.
same as 2 নিয়ে নিন ওটা ওইগুলো নিয়ে নিন it's not today হলো তো এটা কার রয়ে গেল দেখি দেখে নিন কার আছে সেভেন কল করে দিন একবার না মুখে বলেননি তো
Mr. Bhaskar Nandi is appearing for private respondent. He is suffering from fever. I have been instructed
wait
over
then if he is
telephone for not an one day accommodation work.
one day only not today will do
Not today.
not today tomorrow
Hearing matter.
hearing matter only the first half
I have been. Allegation দেখেছি মানে ঝাড়খণ্ড আছে
আচ্ছা yes sir
Oh, no. I'm sorry, my lord. Another matter I have just now read.
My lord, in this matter, I applied for an interstate route, my lord. My lord, page 22. Asansol to Hazaribagh,
yes
along with the representation. Page 18,
page 18
type portion, my lord, 80.
yes
Whereby I have stated that this particular permit, one permit on this particular route, page 27, has been surrendered. Or initially, one permit has been issued by the State Authority of West Bengal in favor of the petitioner and his brother. My lord, page 27. My lord, since my lord vehicle was in the name of one person, my lord, authority declined to issue permit. My lord, that's why my lord, the petitioner along with his brother surrendered that permit. Page 27. Immediately on surrender of this permit, immediately petitioner himself alone, my lord, applied for the self-serve group. That permit has been rejected with a page 27.
Where is the order of rejection?
My lord, page 16, agenda 12 December 2024.
Page 16.
Page 16, operating question, page 17.
Yes.
Ratan Kumar Pramanik, petitioner before your lordship. One application.
As there is no vacancy.
One application, there is no vacancy at this point of time. But your lordship, kindly have a look at page 27. I have surrendered this one.
Yes, Mr. Devra, if permit has been surrendered, that itself will create a vacancy.
Create a vacancy, thereafter, my lord, we have to, vacancy has to be declared in terms of the division budget order passed by the Supreme Court. So, my lord, unless the vacancy is declared, well, till there is no vacancy, because if he surrender, then process shall be completed. Then his
Yes,
application,
Mr. Bhattacharya.
He
he has to create.
this permit was issued without declaring any vacancy.
That is
No,
another
if it has been done, what was done illegally at one point of time does not mean that it will be done every time.
division bench order.
By my respect to submission to your lordship, movement both the authority entered into a reciprocal agreement by notifying the routes and declaring the vacancy.
Where vacancy declaration, he says, has not been done.
In the notification.
Which notification?
In the
After surrendering.
No, reciprocal.
After surrendering.
No, my lord.
If you surrender it once, you have taken a permit in respect of a vacancy. Upon permit being granted, the vacancy is filled up. Now you surrender. Your surrendering will create a vacancy, but till such time the vacancy is published, you will not get a right to be absorbed or considered. That is what his submission is.
My respect to submission to your lordship, the reciprocal passport agreement has been entered by the both the states.
So what?
In this agreement, well, notified route is there, and vacancy has been declared on the basis of that notification.
Only declaration will not do; it has to be published also.
It has been published.
When? After you surrender.
In the Calcutta Extraordinary Gazette.
After surrender.
But before issuing this permit, my lord, your lordship kindly consider. Before issuing this permit,
Mr. Bhattacharya, you kindly consider the court's angle. If a vacancy is published, in response to the publication, you make an application, you are granted a permit. The moment you are granted the permit, the vacancy is filled up. Right or wrong?
My lord, not that, my lord.
No, it will not be filled up.
But no vacancy was declared after the notification issued in the year 2004.
So therefore, it will never be declared. The moment you go, you will get a permit. That is the law. Show me that law, sir.
In terms of the reciprocal
Show me
agreement.
show me that is the law, that it is that no notification, no publication is required. That will breed arbitrariness. If I don't publish vacancies, I will be picking somebody, choosing somebody, and granting him permit. That can't be the law.
That's why
That can't be the law. That cannot be the law. It must be published.
That's why Gazette notification has been published.
Gazette notification when?
But 2004.
2004 is gone. You have already submitted. You have got the permit. When have you surrendered? You have surrendered. You have surrendered in 2025. After surrendering, this vacancy again has to be notified.
I have been granted permit on the basis of the notification of 2004.
When have you been granted? In 2025?
Yes, my lord.
Before surrendering, you have been granted. That has been surrendered now. That has been surrendered now. After surrendering, that vacancy again has to be filled up in accordance with law. It cannot be filled up merely on application.
In accordance with law means by that in terms of the Gazette notification.
Upon publication.
That has been published.
Has been published before surrender, not after surrender. Has to be the law.
There is no such law.
It has to be the law. If vacancy is created, it has to be published again.
There is no such law.
It can't be so. It can't be so.
Your lordship highly consider no such law. Let him show that there is law.
That the moment you surrender, you will be entitled. You surrender, you make an application, you will be entitled to it. That is the law. That is the law according to you.
Section 80 is the liberalized policy. Section 80 is the liberalized.
Section 80 says that you surrender and you apply, you will again get it. That is what Section 80 says.
Section 80 that is not so.
So you are yourself saying that is your case.
Your Lordship,
You have
I-
come up with that
Your
case.
Lordship, kindly come to section 80.
Yes.
An application for a permit of any kind may be made at any time.
Yes. Application can be made, but it should be granted the moment it is made. Show me that.
An application for a permit of any kind may be made at any time.
Yes, it can be made at any time, but can it be granted at any time? The moment it is made, it should be granted also. Where is that?
Now, section 2.
Yes.
State tax authority or any prescription referred to in subsection 1 shall not ordinarily refuse.
Ordinarily.
Ordinarily refuse to
Yes.
grant an application for permit of any kind. Made
Yes.
any time under this act.
Yes.
I mean, in a methodological judgment.
No, you show me that law that the moment there is an application that has to be allowed.
Yes, but that is my lord.
This has to be allowed.
Subsection 2.
What? What does section 2 say?
Subsection 2 that says so.
It says it
Shall
is
not
the moment.
ordinarily refuse.
Ordinarily means, why this ordinarily then? It is not an ordinary case. You surrender, you apply, you again get, you again surrender, you apply, you again get. Is that the law?
No,
You are submitting exactly that. You are picking up a quarrel with the court only on that ground.
I could not understand your lordship. What is the law, my lord? What is the law?
That you have to make me understand.
What is the law?
You show me what the law is.
But according to section 88, subsection 1, in respect of an interstate permit, an agreement is to be entered by both the states, and that agreement is to be published according to in terms of section 88, subsection 5 in the official gazette. But in that notification, vacancy is there, quota is there, West Bengal 2, Jharkhand 2. In terms of that notification, no publication has been made, no vacancy has been published till date. On the basis of such notification, I have applied, I have been granted permit. Thereafter, I have surrendered, but there is no further requirement of any publication of the vacancy. Since already vacancy is there in terms of that notification, which has been published in terms of section 80, subsection 5. Before grant my permit, no publication was vacancy.
Before, please forget, that is not the law. If something has been done illegally, it has to be repeated.
No, it has not been illegally by law.
That is not the law.
It has not been illegally.
It has to be published is the law. If that is the law laid down by the division bench.
Section 80, subsection 5 only says.
If the division bench has framed a modality that it has to be framed.
No, my lord, division bench does not speak so.
Show me the division bench.
Yes, I
does not speak so.
You have the judgment. You have the judgment.
No, my lord, I have no judgment.
Then you are saying it does not speak so. If you don't have the judgment, show it and then say it does
I
not
do not
speak.
find, my lord, this type of judgment.
Very well. Let us see.
I never find. But you must kind of consider, once notification has been published in the Calcutta Gazette, there is no further requirement of any
give me some time,
of any vacancy list.
Give it time. I'm holding it on.
You must kindly consider this very aspect. Once the Gazette notification has been published in the Calcutta Gazette, in terms of the section 80, subsection 5, no further requirement of any publication of any vacancy. And my liberalized policy has been adopted in the materialistic judgment, where it has been grant of permit is the rule, refusal is exception. Judgment difference.
Lordship, kindly take it up at 12:30. I shall bring that.
Come back and let us see the division bench. পাস ওভার করে রাখুন 12টার পরে ডাকবেন
Lord, I appear for the petitioner in this matter, Lord.
I have an application for additional party.
The application or additional party is concerned, Lord, I am not standing in the way of addition. Lord, let it be added by court's order. But the Lordship kindly see, blood. দিয়ে দিচ্ছি নিন কপি নেবেন বলতে হবে কেন নিন না কি বলতে শুনুন না Blood, your Lordship kindly see what it is very simple matter. দাঁড়ান না আমার কপিটা দিচ্ছি আমি Blood, now we are the operators in the restricted field plying the vehicle under the permit and approved timetable issued by the RTA. Now the different association have framed a timetable of their own, sitting over the approved timetable of the RTS, and following the said timetable of the association, various operators are operating their vehicle following the timetable framed by the association, sitting over the beyond the approved timetable issued by the RTA. We raised an objection before the authorities. The authorities held the hearing of the petitioner and the association. On page 30. Page 30 is my objection. You also can see the page 30.
Yes.
That a great pandemonium has been created in the field, restricted field, blood, for which the authorities called the association and the petitioner for a hearing. Page 32. These are the association, includes the association of Mr. Samanta's client. Held the hearing on 10th of June. Matter was discussed elaborately, and the authorities.
10th June, where is that?
On page 32 of my petition.
Yes, 10 June.
Well, held the hearing on 10th June 2025. But no decision has yet been taken, for which a pandemonium is still going on, for which we drawn the attention of the authorities, page 33.
Yes.
Let my only prayer, let the authority took the appropriate decision what timetable is to be followed, whether the timetable approved by the RTA or the timetable approved by the association. Let them take a decision.
Yes.
And the authorities
Yes,
sought to take a decision on this point after holding a discussion among the association amicably so that the dispute can be resolved. If this type of pandemonium is going on in the field, then it will create several problems in the field. Unhealthy competition will be made among the operators.
What is the law? Whose timetable has to be followed in terms of the state authorities?
The transfer of the authorities. The
Yes.
association has no right under the statute to set up parallel
That
timetable.
will make it arbitrary if everybody has his own.
Yes,
timetable,
yes.
Then in that case, it
But
will become
let
difficult.
authority, since the authorities has
Yes,
taken
Mr. Dr.
cognizance, the hearing.
What is the allegation?
The allegation is
This
that
is
they
the
have not
allegation.
taken a decision.
Let me have the petition, my lord, let me go through it, then I come back to it.
This
And
is the
who are
case.
you? How do you seek to be added?
So, my lord, he has made allegation.
Association, he has been heard by
You
the
are the
authorities.
association.
Association of my lord,
Unless I take instruction, I have to go through the petition. What is the nature of allegation?
my lord, this is what I have submitted. This is the case, my lord.
Maybe
and the-
still then I will get a chance.
Very well.
22nd July, Lord.
22nd July, next Tuesday.
My তোমার ক্যানটা তো এসে গেছে এই তোমার ক্যান আসেনি বলছে
This matter was heard in the last occasion. Can you see the page number 15? I'm holding a permanent stage carriage permit on the DN43. We now want to check for person to the permit is renewed up to 15/27. Now the state transport division page number 15. The adopted resolution of 25th January that is 5. Not it is ready goes. So now I have given the fact for me. Page number 21. The date of resolution 25th January 2025. And my lord, the application date wrongly right I don't know that the application date has 20 February 2007.
Yes, according to you, Regional Transport Authority has no jurisdiction. It is to be given by the State Transport Authority.
No, state transport is jurisdiction.
Yes, Regional Transport.
State transport. Now finally, the state transport authority adopted resolution on the route Chapadali bus train to Danpuri.
And jurisdiction vests with the Regional Transport Authority.
Yes,
So this order is without jurisdiction.
According to section 9. Not only this one, government also notification. Page number 29. This case, the fourth paragraph. Henceforth, they after cancel earlier order published by the Transport Department of West Bengal and practices in this regard application for permits of all kind vehicles flying in 3 regions lying within the same state will be made to the Regional Transport Authority of the law says more than 3 regions. Application will be to the region where the major problem falls. But here in this case, my lord, 3 districts applications are accepted by the state and they take the decision violation of the law.
According to you, which authority should have invoked jurisdiction?
That the major portion.
Major portion is within whose? Kolkata region. Yes, Mr. Devray. And how are you otherwise aggrieved, Mr. Khan?
Entire route up to the destination.
Yes.
More than
I think who is it? That is the on earlier day.
Major portion. These are illegal cases on the special bench.
Yes, Mr. Devray, he is entitled to file this writ petition in terms of the division bench and the full bench judgment that he has cited. Prabhat Pan. Because if
what
it is
illegality, I fail to understand.
Illegality is error of jurisdiction.
Error
The-
bit of that
re-
permit was not granted in favor of Mr. Client.
No, but
Client's client.
if any permit is granted absolutely illegally by the State Transport Authority did not have jurisdiction, it should have been granted.
That is correct, madam.
Therefore,
That is correct.
So if that illegality is brought to the notice of court, that has to be corrected.
And the State Transport Authority also rejected, I think so. Not granted.
Let me adopt the resolution. Approved.
State Transport Authority has approved.
Approved. Page number.
Page 21.
How they have approved, I fail to understand. 3 region, 10 minutes, I shall take one instruction. That will be better.
We made the
How,
representation.
how they have 3 to 4, that I have to be ascertained. Which portion they say that this portion is another district, I do not know, madam. There are 3 districts, it is
I said 3 districts.
It is my understanding, and your lordship also understand these 3 districts. But sometime, my lord, one geographical area is there, my lord, in a RTA.
We will let him come with instructions, and if he wants time.
I made the representation also.
Then they will consider. Then let it be disposed.
Which page?
Let it be considered.
Page number 39.
43 number ভাষণ আছে।
I'm a member of this. But application, but representation by the association. But being the repetition is right as per Siliguri judgment that.
Who will consider this?
RTA, AST, State Transport Board.
No, there is no jurisdiction. The question of
They will take decision means there are several respondents. The others who have jurisdiction, they will take.
sending the file to the
Yes, they cannot sit on it. Very-
sending the file to the appropriate authority.
Judgment.
That is better.
Because unnecessarily keeping it pending won't serve any purpose.
There's no need. I am not satisfied.
Yes. I'll come back in 5 minutes. 5 minutes.
Well, in regard to that matter.
Yes. After 2 p.m. If he is agreeable, I don't have any problem.
This is the judgment.
Ulta,
Delivered by
8.
I don't
8
know.
and 11 same matter.
None the Mr. Shaw and other state of West Bengal, 1311 of. Well, the lawsuit had 11 portion only, paragraph 50. Here is the direction. Look at 70.
This judgment relating to a regional transport authority or in respect of the inter-region,
Over.
not for interstate,
That judgment.
not for interstate. In that case, my lord, no.
Originate from ST.
In that case, no agreement was published in the official gazette in terms of section 88.
Cannot ignore that. Principal secretary, they direct the principal secretary. Paragraph 18, Lordship kindly see, principal secretary transport department shall communicate a copy of this order to all RTAs in the state.
That is month order.
The state can-
Huh? Your lordship kindly come to the operative portion of that judgment.
Yes.
The RTA. All the RTAs in respect of the inter-region route or local route
And what is the
notified in
difference
section
between,
71, subsection 3.
what is the difference between that and your case?
That permit is covered under section 71, subsection 3.
Apart from this section, what other difference is there?
But it is interstate. And it is covered under section 88, subsection 5.
So section 71 says that there should be a website publication, or says section 71
Notification.
and 88 does not say.
88 also notification.
So section 71 and 81 both speak about notification.
Notification 71 with regard to the
Only
inter-region.
difference is region and state,
Yes.
and both speak about notification.
Yes.
Then why should this not apply?
My notification, my notification has been published in my case.
And this, in this case, notification
Not-
was not published.
Not published.
Where do I find that?
Yes, my lord, kindly have a look at the judgment. Well, paragraph 15.
Yes, paragraph 15.
The court directs the henceforth all vacancy in any route, on any route would be in.
Well, paragraph 7, you're also paragraph 7.
Publish the
Yes, paragraph 7.
Paragraph 7. By the notification dated 2004 under section 74 3A, individual and distinct routes were created, and the policy on issuing limited permits route-wise was to be followed. Serious problem was faced by the state at the relevant point
So
of time.
there was also a notification here also.
A vacancies route
Mr. Bhattacharya, that means a notification was there in this case also.
Yes.
As you said, there was no notification. That was not the case.
And my 74 3A is contract carriage. My case is about stage carriage.
Sir, the problem is that it is not because of carriage. It is to ensure transparency. What is the objective of this judgment? The objective of this judgment is to ensure transparency, to weed out arbitrariness. Merely because you get angry, therefore you will get an order, is not the case.
My lord, here, my lord, paragraph 12.
Yes.
In the backdrop of the above, the arguments of any lacuna in the selection process adopted by the RTA for holding a permit in
Yes.
route AR3
So what was the
becomes
lacuna?
rather academic.
What was the lacuna?
But AR3 no notification was issued.
Where is it?
AR3 route, in the route AR3, no notification was issued, paragraph 12.
Where does it say no notification was issued? It doesn't say that. That you are reading, but I can't find it. Where is it been written that no notification was issued in paragraph 12?
But notification must be in respect of another route.
What in respect of another? Where has it been said that no notification was issued? That is not written anywhere. I do not know where from you are getting that. You please show me where it has been said that no notification was issued.
Contact auto rickshaw.
Sir, the objective is transparency. For auto rickshaw, they should not follow in respect of stage carriage.
No, it is not for stage carriage.
This is specially only for
Only for auto rickshaw.
and for others they can grant permit to have whoever
You
applies
have also
without
considered this aspect.
publishing it.
My case is for interstate permit, which is covered under section 88, subsection
Very
5.
well, whatever section it may be covered with. The modalities are of both the sections. Modalities of publication should be the same, sir.
Modality of publication is my lord for notification in the extraordinary gazette.
The division bench says I stopped at that because I had an occasion to read this judgment in some earlier matter where you were not appearing, and I had gone through it. Although you were getting angry at that point of time, even now you are angry. Don't get hot-headed. That is not going to help you at all.
No,
that will not change my decision. If I have taken some decision or I am going to take that decision merely because you are furious, I will not change the decision. That is not going to help anybody. We are here. Yes, you are. You are. Try to cool down. Try to come down to earth. Try to come down on earth and then argue your case. I have heard several matters since morning. I have seen you in the first half also. You are absolutely out of your temper. Don't do that.
No.
Don't do that. Don't take this court for a ride. You may know the law very well than me, much better than me. But unfortunately, I am here to decide. And I will decide according to my conscience, according to my understanding of the law. Not because you are saying something, I will have to follow that. Isn't it? If there is a division bench judgment, it may not bind you. But I am bound by that, being a single bench. You will have to show that there is some reason why it should not. The reason which you are showing that it is applicable only to auto rickshaw and not to stage carriage cannot be a reason in my humble understanding of the law. If the division bench judgment, kindly read the judgment. It says that there has to be transparency, arbitrariness has to be weeded out. That was the purpose for which this division bench judgment came.
I agree.
So if that was the purpose, it will only apply in cases of auto rickshaw. It will not apply in cases of stage carriage. I am unable to understand this. Why should this be? If transparency has to be at one place, it has to be at the other place also, at the third place also. At every place there should be transparency.
My humble submission before your lordship. My humble submission before your lordship. Moment a notification is published in the extraordinary gazette of Calcutta in the West Bengal as per section 85. No further publication of vacancy.
Mr. Bhattacharya, suppose, let me learn it from you. A notification is published. Somebody, in terms of the notification applied, he got a permit. Thereafter, he surrenders it. Surrendering will create a vacancy according to me. According to you all, I don't know. Surrendering will create a vacancy or not?
Creating vacancy.
Creating vacancy. Merely upon that creation of vacancy, no further publication is required. It should not be published. No other person should be made aware. No other person should be made aware of that. Mr. Bhattacharya,
anybody can apply at any point of time.
Apply at any point of time. That is why this modality has been preferred. That there should be an awareness among the general people that see there is a vacancy. I am inviting applications. Please apply. That is what the objective of the Honorable Division Bench was.
The paramount object of the Act is the convenience of the commuter in question. Your Lordship kindly consider this judgment passed by the Justice Ruma Pal in the Division Bench. Here, my Lord, paramount consideration is, my Lord, convenience of the commuter in question. But your Lordship kindly, this is also, my Lord, with regard to the interstate permit. And there was a rival party. But the paramount object has been yeah. 96 Supreme Calcutta 480.
This judgment also, Mr. Bhattacharya, goes against you. You read Kindly take page 6,
Yes, my lord.
paragraph 18. There is a quotation from the Orissa High Court judgment.
Yes.
What does it say? It is open to a transport authority preferring one applicant to the other. Let us stop here. When will one applicant to the other be preferred? When there are several applications. When will several applications come? When there is sufficient advertisement of the vacancy. When will there be sufficient advertisement of vacancy? If the vacancy is published and advertised. How will that be advertised? That has been said by the division bench in this judgment. You say it is only applicable to auto rickshaw. Now you answer the query of the court. Anger is never a solution, Mr. Bhattacharya. Anger is never a solution. I have also spent some time that side, much of the time. And I have also appeared in very many cases. You are better versed than me, much better versed than me in motor vehicles law. I am zero here. I am learning from you people. But this anger is not going to take you anywhere.
No, if-
The first thing which anger kills is reason. The first thing which it will kill is reason. That is why you are citing judgments which are wholly against you, even on the point on which you have been vociferous since morning.
But, in order to give answer to lordship's queries, let this matter be heard tomorrow. I will come.
Not today.
Relevant same matter. May I
Yes, yes,
take
take
back
that.
the same matter, same principle.
Not today.
Let both the matter. But if I so mal it,
No, Mr. Bhattacharya, I am hurt by the way you behaved. That is not how you behave. I have been sitting here for quite some time. I have been thinking of myself as a member of that community itself because I am there. I am nobody without the bar. And this behavior I did not expect.
I beg apology.
Since morning I have been seeing you have been losing temper. I can also lose temper, but I am not meant for that. I am very small, insignificantly small in the scheme of things.
I beg apology.
No. I am not so big that I can grant or take apology of somebody. I am very humble. I will always tender apology first. I seek blessings of everybody. But this is something which I am not going to tolerate. This is not good because it hampers the decision-making process. It also hampers reason. The first thing which you lose once you get tempered is reason. You study it, you will come to terms with it. The first thing which you are going to lose is reason. Have it cool here. You are arguing for your client, and I am to understand merely because you want a judgment, I will pass a judgment. That cannot be. You always come with a mind that yes, I will get a judgment and go. But I have to understand there is another side to it. I cannot shut him out. Merely because you want, I cannot give you something.
Take it back, my lord, that is the judgment.
No, good judgment.
Judgment,
No. আমি যে জাজমেন্টটা দিয়েছিলাম
apart from that, lordship can allow me. Lordship correct, he said, I have not interfered. Lordship, but one thing, my lord, 2004 notification. Hereafter, my lord, it is the 2025. It's possible, my lord. If anybody goes there, that has to be just to, my lord, avoid the nepotism and favoritism. This judgment was delivered by Justice Manta at the time of hearing. I also there. I see the Justice view. My lord, Justice Manta's view.
That is what I was also trying to convey to Mr. Bhattacharya, that transparency is the objective. There is a vacancy, it has to be made known to several people. Then there will be competition.
Yes.
You will be able to get better transport system. I understand that yes, paramount important is commuters advantage. But commuters advantage, commuters benefit will be seen Only if the best vehicle is there being
Yeah,
plied by the best
that is
person.
said in
How
the
will you get the
petition,
best
Captain.
person? If you can encourage competition, if there are several applicants, I create a vacancy, I take it myself. I create a vacancy again, I take it myself. That will weed out competition. That will keep the best person out of the market. That will breed our arbitrariness. That is what was struck down by the division bench by saying that everything should be published. The moment there is a vacancy, it should be published. Notification at one point of time it was published, therefore it will have currency. Whenever I apply, I will get, other may not get, other may not know that there is a vacancy. You have surrendered, you have lost your right. Somebody else might get there. That was the idea.
Deep low price. My lord, the allegation.
My lord, I am for the proceedings. Service has been completed.
Lordship, I am appearing, Your Lordship.
Yes.
My lord, petitioner is a permanent permit holder since 1976. The permit was last renewal by the State Transport Authority West Bengal on 17th March 2025, and a representation was made by
What is your grievance?
the State Transport Authority Jharkhand is not countersigning my permit.
Not
Countersigning my permit.
countersigning.
Although State Transport Authority West Bengal has been requested.
Yes, madam.
Page 34.
Your Lordship, I have received instruction that there has been an objection in this matter, Your Lordship. I pray for some time to file my report in this, Your Lordship.
They want to file a report.
Let them file.
The petitioner is aggrieved by the inaction on the part of the respondent
Lordship, I am not able to hear the order.
What did you say?
Lordship, I was not able to hear the order, Your Lordship.
The State Transport Authority and the Secretary, State Transport Authority Jharkhand, i.e. the respondent number 6, shall file a report dealing with the contentions of the writ petition, file a report in the form of affidavit. Dealing with the contentions of the writ petitioner in the writ petition within the aforesaid period. Full stop. It will appear on 31st. You file
Lordship,
prior copy with prior service of a copy thereof upon the learned advocate for the petition.
If exception is required, then
I'll have to fix it 2 weeks, 1 week thereafter. The petitioner shall have liberty to file a report, to take exception to such report within a week thereafter. Listing ta pore kore din, list this matter, pore likhe din ekta, list this matter for further consideration after 3 weeks.
Obliged, your lordship.
I'm good. Leave it. Huh? Huh? Not today করা হয়েছে তো।
15. 59. 50. My affidavit of service. I have served everybody. All have received. Yesterday also some officers came and collected the copy of the writ application. That is also there. I have annexed. It's a very urgent matter, my lord. Palpably illegality has been committed by the railways. I am an operator. I have booked some consignments. Consignment was within the permissible carrying capacity. It was examined. Certificate was issued. It was dispatched. It was weighed again at en route at Balasore. The consignment was found within the tolerable limit. Now again weighed at Shalimar. Again was found within the tolerable limit. They have issued overloading based upon miscalculation.
The service was completed only day before yesterday.
No, day before.
Day before yesterday evening, from your affidavit of service 14th of 7th. I'm keeping.
11th I have sent. 11th.
Yes, they have received on 14th. The
14th, but
notice
today we are
itself.
standing on 16th. It is not that
Very
far
well.
that we one
Very
cannot
well.
come. I have served the headquarter.
Very well. You see, if it is served.
I have served the headquarter.
Yes, yesterday evening.
No, the first page.
What interim order do you want now?
Interim order is, my lord, railways are not following their own rules.
So that interim order will be a vague interim order, na? Let them come.
No. My interim order is this. There is a policy guideline, my lord. Kindly come to page 58. First, what threat I am facing? Page. Yes, page 58. Kindly see clause 14.3. If overloading more than the permissible tolerance, that is 1 ton in case of parcel vans and 5% of permissible carrying capacity in case of SLR, we are concerned only with parcel vans, is detected of more than 2 occasions. In any of the contract, the contract shall be terminated with forfeiture of security deposit. For avoidance of contract will be terminated in case of detection of third overloading, which is beyond the permissible tolerance limit. Now, my lord, they have raised an allegation of overloading against us. They have raised, rightly or wrongly. Lordship, kindly see what they have done actually. Kindly see the punitive demand, which is at page 37. Where is the illegality? I am only highlighting that portion. Lordship has found?
Yes.
Page 37. Kindly see, this is the punitive demand. This is the allegation. Now, kindly see, Lordship, the tier weight. The tier weight is 39.5. That is as per the Railway Board circular. I join no issue with that. Carrying capacity 24 ton. That is as per the policy and as per the agreement. I have to load consignment within 24 ton. Net weight 23.7. It's within the permissible carrying capacity. Now, I have unloaded certain consignments at Bhubaneswar, that is 1.910. So total weight should be at least below 23.7. Kindly see what they have stated, 25.61. So that is a miscalculation. If I have unloaded something, 1.9.
That needs to be explained. On the basis of this, I cannot pass an interim order.
Kindly see the next page. Bear with me for a few seconds. Kindly see the Railway Board, sir. Kindly see they have done their own static payment. Kindly see the static payment at page 75. Lordship has seen 39.5 is the tier weight static payment. Kindly see page 75.
Page 75.
Yes. They have themselves carried the payment of the empty tier. Lordship has found 75 page.
Yes.
Kindly see what they have found. They have found 37,830. They themselves have said 39.5. That is the weight of the empty wagon. Now, after their own payment, they have found it to be 37.830. Now, the difference is of 1.67 ton and the allegation is of 1.61 ton. It squarely gets covered up as per the railway board's own circular. The circular, my lord, kindly see page 76. I'm only highlighting the illegal part. Page
Yes,
76.
but what interim order will I pass on
Interim
this?
order is this, my lord.
What interim order?
I need not pass any order. Not you
Ah.
can hear me for once. If
No,
this
unnecessarily,
wrong
I'll
calculation-
not be proceeding further because they are not here. I will not be able to pass.
I'm only satisfying my conscience before your lordship.
No, no, that you will do in their presence because
Because the threat is this: if on the basis of wrong application of circular, if on the basis of wrong miscalculation of weight, if I am saddled with the charge of overloading, the amount I have paid on protest, and I have reserved my right to approach this honorable court, and if this overloading persists, this false overloading persists as per my submission holds, another two miscalculation or mistake on the part of the railways will cancel my terminate my contract because I have already secured the railways 43 lakhs as security deposits. They will forfeit that. So this is my lord, on the basis of their own circular, they have to adjust it because empty tier is 39.5, static payment comes to 37. So the difference is of 1.67 and overloading charge is 1.61. So there is no overloading in the eye of law. If the railway board circular is to be given a weightage, if their own calculation is proper, then there is no overloading.
Mr. Bhattacharya, if
Mr. Roy.
sorry, if
Now you can ask me any question.
if any of such kind of an act is done by the railways, that can always be undone by court. It is not that you will be remediless. Let them be here, unnecessarily creating. No, no, you serve on the Ministry of Law. I have said you times without number, without service. This service also will have no effect because there is a notification issued by the High Court.
Which says, general order on the basis
no,
of
it's
that.
already there.
Start.
It's already there. It's not my order. It's already there by way of a notification.
For yesterday, my law clerk went to serve them. They said, please show me your. Only then I will accept service. Or else I will not. This is the field reality, my lord. I'm telling you.
No, you meet the ASG. ASG has the
Now,
notification.
What is the system in the state government, my lord? They have their own councils activity. In case no one appears, no one gets allotted, there is a mechanism in place. But there is no such mechanism so far as the union panel is
No, it is to be served on the Ministry of Law and
standing
Justice.
councils.
Ministry of Law and Justice.
Emergency. My lord, because I am operating every day, and because of this shock, every day I'm underloading the consignments because I don't know whether they will again miscalculate and charge and they will terminate my contract. This is happening on a regular basis. Lord, she can pose me any question. I'm only telling my lord.
I understand that.
Similar 3 matters which appeared on.
This will also appear on Friday.
Yes.
Yes. Affidavit of
For Union of India also.
My lord, paying for not today.
Not today.
I'm appeal. How many not to the?
Which one?
16. Sorry.
देखिए
In 17, I appear for the private respondent. On the last occasion, it was taken up by your lordship on the lord 15, on 14, your lordship. There are on many occasions.
लिखे नहीं तो and none appears for the petitioner even today.
I'm appeal.
Mr. Samanto had appeared. না না অন্য ম্যাটার দিয়েছেন আপনি 18 অন্য দিয়েছেন ঠিক ফাইলটা দিন
3297.
2024 তো
2024.
passed over.
Illness cannot stand on that.
একটা অর্ডার রেকর্ড করে নি
I'm appeal.
I received the My report during my illness, madam. Your lordship kindly adjourn the matter for 10 days, madam. I shall come back with the exception to the report.
একটা অর্ডার রেকর্ড করে নিন মিস্টার সামন্ত। টেন ডেজ জুলাই 25 না জুলাই 28 করে দিন 28 জুলাই 28 জুলাই 28 মানডে 28
28 minutes, I have record part.
Come for the petitioner, Advocate Shankar Nath Mukherjee is not present. I'm praying for the one bigger John, my lordship.
he is ill.
Yes, lordship.
She just now prayed for. Yes.
Lordship, I appear on behalf of the petitioner. I appear for the petitioner, Lordship. We've been served with a copy of the report. Lordship, pursuant to your last order, the railway
You
authorities were
want to take an
directed.
exception?
Yeah, we'd like to file a reply, Your Lordship, to the report.
You want to take an exception to the report?
We will, Your Lordship.
Very well. Report filed. How much time you need?
Lordship, week's time?
Weeks. Report filed.
There's nothing substantial in the report, Your Lordship. Your Lordship.
Taken on record. Yes.
No, the just a moment. But may it be in the first week of August. That is my only request.
আচ্ছা তাহলে ওটা রিপোর্টের টাইমটা 2 weeks করে দিন অ্যাফিডেভিটটা হ্যাঁ
But I must point out, Miller, your lordship in your lordship's last order had directed the railway authority to indicate the time. But that has not come up in the affidavit.
That will
Be
see
that
when
as it.
ওই টাইম শর্ট ফর 2 weeks করে দিন তাহলে অগাস্টে চলে যাবে কারণ এক সপ্তাহ দিয়ে তো অগাস্টে যেতে পারবেন 2 weeks করে দিন তাহলে অগাস্ট ফার্স্ট উইক ইউ ওয়ান্ট তো
Yes.
let it be on 4th করে দিন 4th না 4th will be monthly list 5th 5th August.
I'm deeply obliged. My lord.
5th. 5th. Yes.
23, Mr. Sen, my lord, appeared.
Acha, pass over. 23 and 25. Passed over 2 p.m. We'll call at 2 p.m. Oh, then 23, 24, 25 all passed over then.
24 is separate.
24 and 5.
Very well. তাহলে all 3 at 2 p.m.
2 p.m.
/ 26.
Yes, exactly.
Yes. Yes, sir. What is the matter?
Impute decision merit page 59.
Page 59. Yes.
Merit page 49 is the order passed in connection with the earlier section resolution and my lord, in my lead petition. Page 54.
Yes.
Earlier resolution merit page 43, 48.
Page
48.
/48.
The same resolution merit was taken 48. One quota was vacant for the interstate route as stated above. Members of the RTA could consider and allow the application mentioned in serial number 1 written and allowed the application. No reason why my application was rejected, page 48. That's why I came before this honorable court.
Here it says that it has been rejected on the ground of first in, first out.
Method. Though my lord, it has been rejected in the earlier occasion in my petition, page 49. Page 50, paragraph 6.
Page
50, paragraph 6.
The same ground was taken.
Same ground.
Yes, sir. 2 p.m. এটা ফেরত দিয়ে দিন। হ্যাঁ, দুটোর সময়।
$7 million for the private respondents.
I'm for the petitioner. This is a matter of
Pass
that
out.
matter. That matter, my lord.
Why?
Let it be taken up at 2 p.m. No, 2 p.m. থাকে না।
Not today. I'm making not today. Come to what today.
Tomorrow. Tomorrow.
My lord, we have obtained instructions. My lord, as your lordship suggested, my lord, we can go back and my lord ask them to consider representation. Only one request, my lord, our contention was that my lord, there could not have been an unilateral modification of the contract by subsequent.
I'll say that.
Yes.
I'll say
Now,
that.
my lord, only one thing. If your lordship looks at the last amendment, my lord, which your lordship will find that my lord, page 131, which
Page
we have
one.
also my lord questioned here. But at least, my lord, in the meantime, let them comply with this. Because otherwise, my lord, my rakes, my lord, they're using it without my consent, which in terms of the
We'll say that. I'll say that you will consider this in the light of this. Consider the representation in the light of this.
No, my
Because
lord.
if I'm sending
No, my
it
lord,
back,
with the greatest respect, my lord, my representation is that, my lord, none of these, my lord, modifications now apply. Because, my lord, my contract was concluded in 2022, when, my lord, only the clarification of 15th November 2022 was available. I have challenged, my lord, all these subsequent amendments. But, my lord, my learned friend's contention naturally is, my lord, these amendments will have to be abided by. But I am only praying that, my lord, let them consider my representations already made, which are on record. And, my lord, in the meantime, they shall abide by, my lord, this, my lord, amendment number 6, which, my lord, is their own, my lord, notification. Because, my lord, they are not even abiding by this. Kindly see, my lord, just one document.
but these two modified by the later amendment.
No, this is the last amendment.
This is the last amendment.
This is the last amendment.
After 2022, there has been no amendment.
No, my lord, I am talking about the 2028 amendment, that is at page, my lord, 131.
131. Sorry, I
This
was
is
seeing
9th
121.
August or September 2024 amendment. I am saying that without prejudice to my rights and contentions, pending, my lord, determination of, my lord, or, my lord, pending consideration by representation, let them, my lord, at least.
Yes, where is the union?
My lord,
can you call him?
I called him right now, Lordship. He is not picking up. Mr. Kumar Jyoti Tiwari.
Mr. Moti Sagar Tiwari appeared, not
yes,
Kumar
Moti Sagar
Jyoti.
Tiwari.
Moti Sagar Tiwari appeared, not Kumar Jyoti Tiwari. They are different. You have called on another person.
Moti da আছে, Moti da.
I'll pass that order in their presence. Let them come. Because I'll be disposing of the writ petition.
Yes, my lord. Very well.
If they come. Should I take it up 2 p.m. then?
I kindly do that, yes. That's right. I'm grateful.
And I'll also say that it will abide by, it will not be in derogation of the arbitration clause. This consideration of the, so that also remains open. I'll not shut out any remedy.
That's it. Very well. ওইটা দাও, ওইটা দাও।
My lord,
he will now start hammering for interim order. He has.
No, I in this matter I will not hammer for interim order. I have no scope for interim
So
order.
till Friday, if he wants.
I'm candidly saying, my lord, there is no scope for interim order. It's only about refund. My lord, may I say only this? Lordship vividly remembers this matter because this
Yes,
matter
yes,
is
I remember it.
res integra. Law is settled. It has been further settled. The judicial pronouncements of division bench judgments on this issue. I took part in a tender.
I remember it, Mr. Rai.
Now, my lord, my money has been. You will use the word illegally. My money has been blocked with the railways. I am an unsuccessful contractor, unsuccessful bidder. I am not a contractor. I am an unsuccessful bidder. Now, my lord, that money is required by me to take part in other contracts. There are certain eligibility criteria as specified by my learned friend's
Mr.
client.
Das, on Friday, then you please do it because.
Yes, I understand the predicament of the petitioner.
Yes, it will be embarrassing.
And they have already complied in similar cases. I have
and if
those.
that has been complied with in similar cases, you come and say, I'll pass that order. Because since you are there, I can say that to you.
Because
Since
We are the
Mr.
officers of the court, my lord, we need to assist at least so far as the settled law is concerned. I am there to
No,
assist my
Mr.
lordship.
Mr. Rai, since Mr. Dey is there, at least this court,
Yes.
I mean, reposes full faith. He'll come and say if it is no case, he'll say that there is no case. He'll not argue unnecessarily.
Because I tell you one thing.
So if it is something which can be done at the first go, it will be done at the first go.
Yes. Why I say, my lord, in the second matter, which is appearing along with it, railways have filed an exception. In the exception, similar matter, no difference. In the exception also, they failed to annex any document to highlight that there was a proper acceptance of the bid. If as a, no, he is not in the second matter. If there is no acceptance of the bid, just by participating in the tender,
You cannot have a. You cannot be said to be a bidder.
Yes.
Successful bidder.
Because Section 7 of the Indian Contract Act stares at us, my lord.
There has to be acceptance of the
There
proposal.
has
Is
to be
that
an
there?
acceptance.
That's too
That
elementary.
is the only issue which has been dealt by the division bench, and similar order has been passed and amount has been refunded.
Mr. Dey, please. See if
I will come on Friday. and I'll-
I'm making it just not today. It will be coming on Friday. It's a Friday করে দিন। আচ্ছা লিখেই নিন একটা order record করে নিন। On the prayer of the learned advocate appearing for the respondent. নেক্সট ম্যাটারে 30 কল করুন দিদি 30টা আলাদা কল করুন হ্যাঁ 29 সেপারেট 29 টাইম হলো 30 লিখুন হ্যাঁ 30 লিখুন
30, my lord, I will be filing my
None appears.
One week adjournment. Shankarnath Mukherjee is not present.
He is ill.
My lord, I am appearing on behalf of Union of India.
Item number 34, I am appearing on behalf of the respondent number 5. Day before yesterday, I received the power from them. It is actually situated in located in Pune, and instructions are received that I may be given a short date for filing the opposition and this is the matter that I will decide. A short date will be given, and by my
লিখে নিন
Well, I could not find the affidavit service because the return service could not come. I am unable to get it.
Very well, now he is appearing.
Because they are appearing, my lord. I'm so grateful.
Lord, I am for the petition.
My lord, 33, my lord, I am for the state. For my suggestion, sir. My lord, this involves two districts. I have got report from one district. My lord, I have yet to got report from another district. I am praying for Surat. Got a comment?
My lord, simple prayer, well, for extension of route for only 15 kilometers, which is permissible under the law.
No, my lord,
Yes, yes.
my instruction is it cannot be permitted. That's because he has already made a sample.
So what?
No, that increases the report.
No, 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 my lord.
But
My lord, kindly come to only one document.
the next week,
Yes, my lord, kindly for my friends, my lord, kindly come to page 18. No. Kindly come to page 18.
Yes.
Distance certificate issued by the Public Works Department, Purva Mednipur, where it has been clearly stated that the bus stop to Purva Mednipur border at Jahalda is 14.25 kilometers only. And my lord, next page, that is page 19, Google Maps shows also it is 15 kilometers.
in the RTO files the report.
Yes.
No, but you took time on 2nd. Now we are on 15th.
Yes, my lord. That is my
You sought for a week's time only.
My lord is absolutely. Because two districts was involved, I was not aware of that question. I just praying for that.
Learned advocate.
Lord, I'm
34 years old. Let me miss out.
but I'm for the petition.
Yes, that matter. No?
Yes, four like
That agreement matter.
yes. Well, may I submit? But kindly come to section 1 second. Section 86(5). Where a permit is liable to be cancelled and or suspended under clause A or clause B or clause E of subsection 1, and the transport authority is of opinion that having regard to the circumstances of the case, it would not be necessary or expedient so to cancel or suspend the permit if the holder of the permit agrees. Well, this term is very essential, my lord, for my interpretation. Permit agrees to pay a certain sum of money, then notwithstanding anything contained in subsection 1, the transport authority may, instead of cancelling or suspending the permit, as the case may be, recover from the holder of the permit the sum of money agreed upon. But my submission is, when it is submitted that is agreed amount, agreeable amount implies a negotiation or agreement between the authority and the parties. Authority and the person being penalized, which is not possible in a suo motu action, where the authority unilaterally decides the penalty. When a statute uses agreed amount as penalty, it suggests a process where the penalty amount is determined through discussion and mutual consent, not by a unilateral decision. But first question, first submission is. Next, my lord, natural justice.
suo motu action without a chance for the affected party to negotiate or challenge the penalty could be a violation of natural justice. Thirdly, my lord, the authority must follow a process of negotiation or agreement with the individual to determine the agreed amount as a penalty and cannot impose it suo motu. My lord, in support of this, of my contention, my lord, I am referring one judgment. My lord, it is from Jharkhand High Court, division bench judgment. My lord, paragraph 14. Paragraph 14. The law is well settled that the appellate court is having no power to interpret the law. Rather, the appellate court is to proceed strictly in adherence to the statutory mandate on the principle that when a statute provides that a particular thing should be done, it should be done in the manner prescribed and not in any other manner. A reference in this regard may be made to the judgment rendered by the Honorable Apex Court in the case of such and such.
Yes,
Next,
well settled.
Next para, my lord. It is the basic principle of law, long settled, that if the manner of doing a particular act is prescribed under statute, any statute, the act must be done in that manner or not
at all.
The origin of this rule is traceable to the decision in Taylor versus Taylor. Well, next paragraph is also the Honorable Apex Court, para 16. It is a normal rule of consideration that when a statute vests certain power in an authority to be exercised in a particular manner, then the said authority has to exercise it only in the manner provided in the statute itself. My lord, here, my lord, statute clearly stated that the sum which has been imposed by the authority should be agreed upon. But in this context, my lord, I am submitting another judgment. Page 7. Paragraph page 7. My lord, in right hand side, it has been written page. Point number 11. XI. Got it,
Page 7.
Point number 111. XI.
XI.
Its power under subsection 1 of section 86 and subsection 4 of section 88 to suspend a permit or a counter signature of permit and to recover from the permit holder the sum of money agreed upon in accordance with subsection 5 of section 86. Provided that while passing the order to recover from a permit holder the sum of money agreed upon in accordance with subsection 5 of the section 86, the person authorized shall specify there in the compounding money payable by the permit holder in case he agrees for composition the date by which the permit holder is to intimate acceptance of composition and the date by which the composition money shall be remitted and receipt produced, and in determining the sum of money to be recovered in lieu of suspense of permit shall have regard to the nature, gravity, and frequency of the offence committed, the quantum of punishment that would otherwise have been imposed, and the earning capacity of the vehicle with reference to the nature of the road and passenger capacity in the case of stage carriage, daily mileage of the vehicle and higher charges, if any, in respect of other class of transport. Provided further that the amount so recoverable in lieu of suspension of permits shall in no case be less than the amount specified by the government by notification under section.
No, where is this quotation coming from?
Yes, my lord.
This is from a notification, no?
Yes. My lord,
this is part
one,
of what?
Delegation of powers of the State Transport Authority. Page 6. My lord, where 86.5 has been dealt with.
No, it is a part of Odisha Motor Vehicles Rules 1993.
No, my lord, section 86(5) is the mother act.
No,
Section
no, what,
86(5).
no, that the one which you have placed,
Yes.
delegation of powers of authority,
Yes, sir.
this is a part of Rule 41. Kindly take page 6.
Yes.
Page 6, paragraph 10.
Page
Page 6, paragraph 10.
It's power to pass a order.
No,
As
if you see
contemplated by section 2 of
just the previous page,
yes.
just above delegation of power of state transport
Rule
authority.
41.
Rule
which deals with
41.
The delegation
Now
of
this
powers.
rule 41 is part of which rule? Kindly turn over the page, earlier page.
Rule
Kindly
41.
Rule 41. Kindly turn over the page. Come to page 5.
Yes.
Paragraph 8. There is a heading, Secretary, State Transport Authority.
Yes.
Above that, paragraph 8.
In exercise of power conferred.
Yes, this is Odisha Motor Vehicles Rules. So
But
it is in terms of this rule. There was a rule which said how it is to be exercised.
No, my lord. But my lord, in this paragraph, clearly stated 86(5) of
Yes,
the Act.
86(5) of the Act has to be exercised in accordance with this rule in Odisha.
Yes.
It is not to be applicable to West Bengal. Kindly read again.
Section 86(5) is applicable.
86(5) is applicable, but the manner of applicability of section 86(5) in Odisha will be in accordance with the Motor Vehicles Rules 1993, Odisha Motor Vehicles Rules. Kindly, that is why I am saying, kindly come to paragraph 8, read paragraph 8.
Yes. In exercise,
In
of powers.
exercise of power given by 28, 65, 96, 111 and 138 of the Motor Vehicles Act, the state government has framed a rule
Yes,
which reads as follows. Now it is a part of that rules. In that rule, it has been said that 86(5) power will be exercised in this manner. That is a part of the rule, not of the, for Odisha.
Yes.
In West Bengal, do you have that kind of a rule? Then matter ends.
My lord, kindly come to that is my lord, that is the rule. But my lord, I am referring section 86,
Section
motor of the
86 is in
86
the
of the Motor Vehicles Act.
Section 86 in the Act itself.
Yes.
Show me from section 86 does not say all that. Section 86 only says it will be in agreement, in accordance with the agreement.
Yes.
Yes. How that agreement will be arrived at,
yes,
that is said in the Odisha rules, because Odisha is bound by those rules. So far as West Bengal is concerned, if you can show that rule, then in that case I will judge it according to that. But the Odisha rules will not be made applicable to West Bengal.
But here,
try to understand.
Yes.
The rules, you see, the rules refer to several sections. Kindly see, kindly see paragraph 10.
Paragraph 10.
Yes, it does not only refer to only one section. See, its powers under section 72, 74, 76, 79, 88. Then how 88 is dealt with in this chronology, it comes down to 86 in paragraph XI. Right. So this is in respect of Odisha rules. It is not for West Bengal. For West Bengal, if there are similar rules, we will be able to invoke it. But this logic, by mere dint of this, I cannot invoke here.
Yes, my lord, then kindly take it up at 2 p.m.
Yes,
2 p.m.
come back.
My lord, one more thing, my lord. My another interpretation.
Let him complete.
Another interpretation that when
don't you have any
when
rules
the
here? West Bengal rules you don't have.
Yes.
What is there? You see that.
Lord,
that will help you better.
Yes, my lord.
If that rule is there, then in that case your business ends there. If that rule has a modality, it should be in perimeteria. Because as far as I have seen, if there is a rule in one state, the rules in other state are usually ordinarily perimeteria. So here also, if the West Bengal rules are in perimeteria, then your purpose is served.
Yes, my lord.
See how it is said. This is 89 rules. That is 93. Their rule is later.
Kindly take it up at 2, my lord.
Very
good. I shall find.
Very.
My lord, may I wish one matter? My lord, one matter, PA 14037 of for my lord, it was on the last order on 30 June 25. It was said that it was supposed to come
It has not come. Give the list, it will
Sir,
flip, it will
there was a mistake, typically mistake.
list anun na for correction. It will appear. What was the direction?
my lord, kindly come to
There is a continuing matter.
Kindly come to rule 112.
112.
112, 213 and 214.
112.
112, 213 and 214.
112.
Yes. 112.
Yes, 112.
Power of the state government to issue orders to regional transport authority. Paragraph 2, 112(2). The state government may also issue similar orders empowering the Deputy Commissioner of Police, Traffic Department in Kolkata area, Calcutta area, Superintendent of Police in the district to exercise power.
This is how
86 of the
who
state.
can exercise power.
Yes,
But how it is to be exercised?
Next 213.
230.
213.
213.
Yes. 213 Roman 8. Powers under section 86 of the Act to suspend a permit or to recover from the holder thereof the sum of money agreed upon in accordance with subsection 5 of the said section, other than the power to cancel the permit.
There is no other rule.
No. Next, my lord, 214 M.
214
M.
M. It is also agreed upon. How the agreement will be?
No, that is not specified.
Odisha rule is better because it says.
Yes. My lord, my contention is, my lord.
My learned finishes, I will make myself.
I say that you have to pay that. If you agree, not agree, then cancel that person. This is the intent.
No, my lord.
Mr. Samanto, my reading of judgment is also, if there is a rule which says that this is the manner in which power will be exercised.
Yes.
That is good enough. But till such time there is a rule.
But the rule does not specify anything regarding quantum.
That is the problem.
But
See what happens, Mr. Samanto, is it speaks about agreement.
Yes.
Agreement will entail two things: proposal and acceptance.
Acceptance.
Now there is a proposal.
Yes.
There is a proposal. That proposal is not accepted. What happens? There is no agreement. So you are not required to pay. If you don't pay,
not only that, my lord, discussion, negotiation, everything will be there.
Very well. Suppose you don't accept.
Yes.
If you don't accept, then cancellation will be the only consequence.
But the quantum of money, my lord,
that also Odisha judgment also says frequency of offence, gravity of offence.
Not only that, my lord, other criteria.
Yes, but frequency is there.
Other criteria.
Now your case is admitted 3 times.
Yes.
So if it has been thrice violated, and there is a division bench in session of the matter saying that see that there is no violation, if there are 2 violations or more than 1 violations, you initiate proceedings, then in that case
my lord, my question is quantum of money.
That
lord,
I understand.
I have agreed.
But till such time there is a regulation in the form of a rule
my lord,
by the statute.
Kindly, my lord, kindly allow me. The petition, the permit was issued against BS3 model vehicle. But if the permit is cancelled, this BS3 vehicle will be ruined. My lord, the vehicle will not get any permit in anywhere. But only because, my lord, the petitioner submitted. My lord,
I'll please the law.
My lord, only because the petitioner submitted his representation to allow him to fly his BS3 model vehicle, and he is agreed to pay a sum of rupees 25,000 as penalty. Well, this is my submission, my lord. My lord, I only disputed the agreed amount.
Very well. Let me hear.
Prior to citing other judgments, Your Lordship, first I would like to draw your kind attention at page 40.
Any other judgment, Mr. Samanto?
No, madam.
Odisha would have helped if it was instead of Orissa, if it was West Bengal.
At page 40 of the writ petition, if I may please once, Your Lordship,
Page 40.
Which is internal page 4 of the judgment and order passed in writ petition number 3838 of 2026.
Internal page 4.
40, internal page 4.
Page 40, internal page of the order.
I'll place paragraph 9 once before I am going into the judgment. The petitioner in the case has accepted the allegation of violation of the permit conditions and entering into the restricted zone for plying his vehicles. Under such circumstances, the fact of violation by the petitioner is already established. This would generally render the petitioner's permit liable for cancellation in terms of the court's order. However, this court finds that under section 86(5) of the Motor Vehicles Act 1988, the statute has provided discretion on the transport authority, which may be exercised for recovering requisite fees from the concerned violator instead of cancelling or suspending his permit. The discretion point has been held in my learned friend's case as well, in this writ petition. This hasn't been challenged as of now. Now, your lordship, if I may place, discretion may agree or may not agree. Now, if I may place your lordship, firstly, a judgment of High Court of New Delhi. I would beg to place your lordship paragraph 17 onward.
Paragraph 17. 17.
17. Section 86 of the Act, as has been seen earlier, arms the transport authority which grants a permit to cancel or suspend the same for such period as it thinks fit under certain conditions. One being breach of any condition as specified in section 84 of the Act or of any condition contained in the permit. Then paragraph 18 start. I'll skip these two pages, your lordship. I'll again start from page 9. Paragraph 90. Your lordship has got that?
19.
Lordship. Any action by transport authority under section 86 is in the nature of administrative quasi-judicial function where there is no provision of any trial. The operation of section 86 of the Act is independent of chapter 8 such and such. Paragraph 20, lordship, subsection 5 of section 86 provides for substitution of fine in place of suspension of the permit. The fine which has been paid by the driver of the vehicle is for violation of some of the directions such and such and not under section 86 of the MV Act. Under section 86(5) of the Act, there is provision of fine in place of suspension of permit if the holder of the permit agrees for the same and if the same is considered to be expedient by the authorities. The petitioner in present case could have offered to pay fine instead of suspension of permit for 5 years. So there is this, either you pay the fine or you continue with the suspension or termination in this case. Now, your lordship, lastly, I would like to place 1993 SC.
Now, the fine that you are imposing, whether that fine is reasonable or unreasonable,
Yes.
how will that be understood?
Yes. Lordship, I'm coming in.
Suppose you, one fine morning, you say that you pay 1 crore.
Lordship.
Then how will the court ascertain as to whether the fine that
If I may place 1993 judgment once. It has dealt in exact way the present. It's a reported judgment. 1993. 1993 your lordship, आपने अपना soft copy पढ़ा? अपना नाम बताओ. Lordship, if I may place paragraph 3. Now the question is whether for broken seal, the motor vehicles authorities can unilaterally realize a fine of ₹500 or any amount under section 86(5) of the Motor Vehicles Act. Rules 262 of the West Bengal Motor Vehicles Rules 1989 contains provisions regarding taximeters in respect of motor cabs in certain areas mentioned therein, including Calcutta. Sub-rule 4 of the said Rule 262 provides that any owner, driver, attendant, or any other person who shall break or in any way tamper the seal placed on the taximeter or the driver mechanism thereof, or who shall with intent to deceive tamper with the taxi driving mechanism thereof, who shall with intent to deceive the tamper with the taximeter or driving the mechanism thereof, shall be deemed to have committed a breach of this rule. The conditions of permit for taxi is stated to contain a specific clause that the permit holder shall comply with all relevant provisions of the motor vehicles rules, and any breach of rules shall be treated as breach of condition of the permit. Therefore, if any owner, driver, attendant, or any other person breaks or tampers with the seal of a taximeter meter, he commits a breach of Rule 262 of Motor Vehicles Rules 1989 in view of Sub-Rule 4 of the said rule, and thereby violates a cause of the permit granted for plying the taxi, namely the cause that requires the permit holder to comply with the provisions of such and such and such. Provides that whoever contravenes any provisions to the Act, regulations, or notification made thereunder shall, if no penalty is provided for the offence, he shall be punishable for the first offence with a fine which may extend to 100, and for any second or subsequent offence of fine which may extend to 300. The offence of the breaking or
Yes, I have read it.
Your Lordship, I'll just continue because
I have read it. Paragraph 3, you read the last portion only. You don't need to read the
Lordship,
entirety of it.
obviously a
You
plain
read from
reading of
obviously.
subsection 5 of 86 will obviously a plain reading of subsection 5 of 86 will show that Transport Authority has not been empowered to. Your Lordship has got this obviously.
Yes, I said you read from obviously, and the
Lordship,
relevant portion is just above paragraph 4.
Lordship,
If
if the person concerned does not agree to pay the proposed amount, the Transport Authority cannot insist upon payment of the same, and in such authority can only initiate action for cancellation or suspension of permit, and for that purpose call
that
for
was
an
my reading of the section also. That is what I was just now telling to Mr. Shin.
Now, the question of your Lordship, as it has fallen from this court, your Lordship, that whether the quantum of the fine, the statute is vacant about that. It cannot be on the mere interpretation of an offender who has offended it for 3 times. The discretion point has been recorded in the order whose benefit he has taken before replying to the show cause, your Lordship. He has an option either to pay the fine, or we are at liberty, we are not at liberty to insist upon realization of the fine. We are at the liberty to continue with cancellation or penal measures.
Yes, Mr. Samant.
My lord, question is, my lord, only the quantum. It is admitted the owner of the vehicle, the petitioner, violated the permit thrice. And my lord, for violation of permit condition, there are specific provisions for giving penalty. And as my lord, only the petitioner have already paid 3 times the penalty for violation of permit. And first of all, and second, my lord, the petitioner has submitted one representation with the for payment of some amount for such withdrawal of 4 lakhs rupees. That is my submission.
25,000.
Well, only quantum is very, very difficult. But otherwise, my lord, the vehicle of the petitioner as BS3 model vehicle, that will ruin. And bank EMI is also
To
there.
assess the reasonableness of the quantum if the rules are silent.
My lord, may I suggest, my lord, let the matter sent to the authority again for a reconsideration.
I will have to set aside that order then, but there is no ground.
Well, ground is only the quantum, how they decide the quantum.
Quantum, though, it is dependent upon the agreement. There is no rule which regulates the prescription of the quantum.
But here the clause of agreement has not fulfilled.
Therefore, there is no agreement. If there is no agreement, they will cancel.
The
agreement, whether they will prescribe or not, is at their discretion. They can also go directly for cancellation. It is not necessary for them to say that I will ask for this much of fine, you pay this fine, and then only after prescribing a particular amount for being imposed as fine, they will proceed for cancellation. That is not the law. They can proceed for cancellation even without asking you to pay fine. That is the law.
Yes.
It is in their discretion, if they exercise discretion in such a way that they can also say that, okay, in lieu of cancellation, you pay this much of fine. So this is not mandatory. So if it is not mandatory, then in that case, unless there is a regulation by the rules.
For these reasons, my lord, the petitioner filed this application before
I understand that.
honorable court.
Let us see, I will have to decide that.
For interference of this honorable court, so that the petitioner.
I will need to decide that.
My lord, only thing, my lord, it is very difficult for the petitioner to pay sum of rupees 4 lakhs.
That
only
is difficult.
This thing, my lord.
Let me
My lord,
consider it.
sympathetically, my lord,
I will
not in mechanical ways.
I will reserve judgment. Let me consider it, because this is one case which I need to decide.
My lord,
I have
my lord, a petitioner with BS3 model. My lord, a petitioner with BS3 model vehicle, where he will go.
And where is that pleading in your writ petition?
Yes,
It's there.
I have stated. My lord, page 16. Sorry,
Page
paragraph
16.
paragraph 16. Paragraph 16, page 10. That is
Paragraph
petitioner
16, page 10.
Petitioner states that he confessed such guilty, and for the said offences, your petitioner paid penalty of rupees 10,000 as prescribed fee in the Act thrice for such violation of permit condition, and by letter dated to 5 June 2025, your petitioner submitted his willingness to pay rupees 25,000 as penalty by stating that unless the decision of the authority dated to 21 April 2025 is revoked and or cancelled, your petitioner would not be able to ply his BS3 model except this route, as the petitioner would not be able to obtain any permit in future against the BS3 model vehicle.
Record.
That is my submission.
There is no law.
So much money, my lord.
Such time that there is a regulation, I don't know what I will do. Let me say. Let me think over it.
It will be very difficult for the petitioner to pay.
I will also do my own research if I can find some judgment. And if any one of you can find any other judgment till such time that I have not delivered it, you can hand it up to me.
Yes.
If in the meantime, if you can find something. But if I deliver it, then after that it will be of no use. No, Mr. Samantu relied on a judgment of Odisha High Court. Odisha has rules. That rule has prescribed the manner in which this agreement is to be entered into. Here we don't have any such rule. That is the problem.
Only violation of permit schedule is there, penal provision.
That schedule is there in our rules.
3 times I have paid, the petitioner paid for violation of permit condition.
It has been recorded in the Oswald petition also that the petitioner is a habitual offender. Every time he comes.
Where is that division bench judgment? Very well. Chalo. Past over group. Yes.
Well, it is that matter. Where my petitioner's claim is that relief sought for.
If I correctly remember, it is that tax cannot be asked to be paid till such time the counter signature is done.
Yes.
Only after the counter signature is appended that the petitioner will be liable to pay tax. Not before that, and for that purpose, a division bench judgment was relied on.
Yes. Now, my lord, my contention was that I have filed one report. In the report, my lord, it has been, my lord, specifically the averment is that so far the permit is concerned. If your lordship kindly have a look, my lord, the permit, my lord, permit renewed at page 21, renewed by the permit issuing authority at Jharkhand.
page 21.
Yes.
Now, my lord, because this is the, my lord, his main case, that the permit, after having been renewed by the permit issuing authority, then the countersigning authority should countersign, and on and from the date of counter signature, the respective state can demand, or I am liable to pay. Now, Roshi, kindly come to page 21. That endorsement on the renewal, page 21, Roshi, got it, my lord? Yes, this is the, my lord, the after renewal, the permit issued. Serial number 11. Have you got it? Serial number 11. Validity of permit from 20th January 2024 to 19th January 2029. Now the signature or the renewal was done on the next page 22 by the permit issuing authority on 16th of January 2025. So after the expiry of the permit in January 2024, though the renewal was made on 16th of January 25, but the effect has been given, as it appears from serial number 11, that the permit valid relates back to 20th January 2024. Why? Why this, my lord, that from 20th January, that means the validity of the permit under section 81, 5 years. And then in case of renewal, kindly, my lord, in my report, I have stated that section 81, have you got it, my lord? The
Yes.
Motor Vehicles Act, section 81.
Yes.
Duration and renewal of permits. There cannot be any gap, irrespective of the fact that when the renewal actually is being done, but the effect should be given from the date of 1 day after the expiry of the permit. Duration and renewal of permit. A permit other than a temporary permit issued under section 87 or a special permit issued under subsection 8 of section 88. Any other permit shall be effective from the date of issuance or renewal thereof for a period of 5 years. First of all, this is the period of 5 years, every permit. That is called permanent permit. There is no expression in the act that permanent permit. No. Either 5 years permit or temporary permit under section 88 for any temporary purpose. Then proviso. Provided that where the permit is countersigned under subsection 1 of section 88, such counter signature shall remain effective.
Yes.
Shall remain effective. We are on the part of counter signature. Subsection 1 of section 88, such counter signature shall remain effective without renewal for such period so as to synchronize with the validity of the primary permit. So my counter signature, irrespective of the fact, when I do sign on it, suppose during the period of 5 years, I sign it after expiry of 2 years. But still, the effect should be given effect to in synchronize with the validity of the permit. Now the validity of the permit as it appears from page 21, from 20th January 2024 to 19th of January 2029. Despite being the fact that the renewal was done in 2025 after about 1 year. So when the permit valid, he has accepted this, that permit valid from 20th January 2024 to 19th January 2029. Then as per renewal clause or my lord enactment section 81 proviso, that when the permit is countersigned under subsection 1 of section 88, such counter signature shall remain effective without renewal for such period so as to synchronize with the validity of the primary permit. So, my lord, the middle portion, again, if your lordship, my lord, allow me, such counter signature shall remain effective without renewal. So here also counter signature remain effective without renewal for that period for which either he did not place the permit or it was not even my lord, the renewed without renewal, but synchronized with the validity of the permit. That means from January 24 to 29 January. Now, if you lordship, my lord, I can read it with my lord Motor Vehicles Tax Act, and my lord, there is an averment in my lord pleadings.
Yes.
Now, lordship, kindly come to West Bengal Additional Tax and One-Time Tax on Motor Vehicles Act 89. My lord, I think the book is
Yes, yes, it is still with me.
my lord, no difficulty, lordship, no difficulty. My lord, West Bengal Additional, my lord, one time, Mr. Enai Khan, when he was my lord retainer on behalf of the state of West Bengal, and the motor vehicle chapter, my lord, regularly my lord, dealt with by him, and he read the book, and he was the my lord, writer of the Motor Vehicle Act, and my lord, this tax act, my lord, it was his duty that to
Yes,
provide the
his
books
name is
with the
here in
judge.
this. His name is there on this book also.
There cannot be any departure right now. I think I shall ask Mr. Khan. Now, my lord, lordship, kindly come to my lord, section 6 of the West Bengal tax, one-time tax on motor vehicle. My lord, kindly come to section.
Realization of additional tax.
Yes, yes, charging section. Section 6, realization of additional tax.
Yes.
The additional tax leviable under section 4 shall be realized by the authority where under any law for the time being enforced, such authority has to countersign the permit. Here I have authority to countersign the permit. So my right is there. And in such case, the tax shall be leviable. This is very vital. The tax shall be leviable for the entire duration for which the counter signature subsists. So this section 6 of the Additional Tax and One-Time Tax Act should be read with the proviso to section 81 within bracket 1 of the Motor Vehicles Act. This tax act section 6, this should be read with, because section 81 subsection 1 of the act says it should be synchronized with the period of the validity period of the permit. That means 5 years, irrespective of the fact when they put the signature regarding the renewal. Then again, section 81(1) says my counter signature shall be in that way, irrespective of the fact when I sign it. 5 years, 2 years gone, suppose either he remains silent or whatever be the reason, but 5 years permit should be countersigned also relates back to that 5 years as renewal done, because they are also, lordship, kindly see the renewal done by the Jharkhand authority in January 2025, but the endorsement on the permit is from January 2024 to 2029, relates back to 1 year. So without renewal, whether he plied his vehicle, did not ply, or plied, no question of. So one thing is very clear, whether you use your vehicle on road or not, that is not the factor. That is not a factor. It is a almost that quid pro quo is not applicable here as per the law. That use it and pay it, use it and pay it. No, that quid pro quo is not applicable because of the language of the both the act statute. Whether you use it or not, whether you got some benefit of counter signature or even that renewal, nobody is on that. The question is, irrespective of the date of renewal irrespective of the fact whether you enjoyed that permit after renewal or during that period, what happened, we are not at all concerned. So far the permit issuing authority, at the same time, so far the countersigning authority. We are not at all concerned whether you did use your vehicle during that period or not, but you pay the tax. Because this taxing statute is in consonant with the Motor Vehicle Act. It sings in same tune. There is no, my lord, discomfort or anything or disparity. Because
yes,
and then, my lord, it is very vital. Section 7, charging section and then computation. Computation of additional tax, section 7. The additional tax leviable under section 4. Madam, may I pause here? It is nobody's case that additional tax is not leviable. Additional tax is leviable under section 4 shall be computed on an annual basis.
The only area of dispute, Mr. Sen, is according to you. I have understood. According to you, once a permit is issued, the counter signature done at the time of issuance of the permit will remain valid for the entirety of the period during which the permit is to remain valid.
Yes.
If the permit expires and it is renewable during the period of the validity, then notwithstanding whether counter signature has been done or not, even if the counter signature is done at a later date, that later date will have to relate back to the date of the grant of permit, and therefore
not relate back to the date of grant of permit. Relates back in synchronize with the validity of the permit.
Yes,
because,
that's it.
Because here the date of renewal by the Jharkhand, January 2025. But the relates back to 2024 January.
Yes.
Because his permit expired in 2024.
Yes. So that
exactly what done by the permittation authority, that should be done by the countersigning authority also. If I countersign this today, then that would relate back to that from the 2024 January. That means the entire 5 years. And
yes,
to
so
synchronize.
So 2024 January is the beginning date of the validity period. That is what I said.
Yes.
Now, my lord, the date of the grant.
Now, my lord, it is also, my lord, it would the same would reflect from, my lord, section 7. Section 7 also, my lord, speak, my lord, in the same.
Yes, I have read validity commences. It says about the date of commencement.
Yes, shall be payable to the authority concerned before the date. Yes, very important. Before the date on which the tax becomes payable. That is the date on which the validity of the counter signature commences.
That is what
it is not the from the date of counter signature. It is from the date of validity of the counter signature. So the moment my validity of the counter signature relates back to January 2024, despite being the fact that in 2025 today in July or August I am going to sign, then the validity of the counter signature.
So according to you, Mr. Sen, no matter when the counter signature is done, once the counter signature is done, the validity of the counter signature will be treated to have commenced from the date of the validity of the permit.
Yes. Yes. And accordingly, the tax should be payable from on and from that date. Irrespective. Now, my lord, I am grateful to your lordship. Now, my lord, I think a judgment, I think already, my lord, it brought to your lordship's notice. Here, বাকি কপি কি হচ্ছে আমার কেউ একজন এটা কপি ছিল ওকে I want to rely upon 2022-5 SCC. 2022-5 SCC, page 525.
Yes.
Now, my lord, so far I remember, lordship, kindly, my lord, do not open this right now. So far I remember here what happened. My lord, a motor vehicle was purchased by a registered owner of that said motor vehicle through a financier company. Now, because of non-payment of the installment to the financier company, the financier took possession of the vehicle. Now, Motor Vehicle Authority of UP, they claim, my lord, the road tax and one-time tax also. They are also one-time tax act is there. Now, from the date of expiry of the earlier taxing validity period, area tax, the issue raised before the authority as well as before the High Court therein, and then matter went up to the Supreme Court. The issue was that the two issues. Number one, that when the financier took possession of a vehicle on a particular date, on and from that date, the financier became the owner of the vehicle as per the definition of the owner in the Motor Vehicles Act. Motor Vehicles Act says that not only the registered owner, Motor Vehicle Clause section definition clause says that owner means also who is in possession by way of lease and other things. So it was not disputed that the financier was not the owner for the purpose of that. But the question is that from which date the financier was liable to pay the tax. The area tax which was otherwise payable by the registered owner from whom the vehicle was seized for non-payment of dues, whether the tax can be paid or liable to pay for that period also by the owner as per the law, not registered owner. The Supreme Court says, and the point was that we were not benefited for that period when it was not in my possession.
Yes.
Why shall I pay the tax when this vehicle we did not ply on road? That means quid pro quo again. The Supreme Court says, Lordship, kindly come to, then my lord, paragraph 4 and 4.2. And advance tax also, they are also, yes, advance tax also, this was also issue. Paragraph 4.1. Or Lordship, kindly come to 4.2. 4.2. It is submitted. Para 4.2.
Yes, one. Yes.
Para 4.2. It is submitted that the taxes due and payable under the 1997 Act, that is the Act of UP, on the use of the transport vehicle, it is submitted therefore, in our statute, only departure is that there is nothing such clause that because of using my road, there a specific clause was there. If you use it, you have to pay. Here there is no such specific clause. But still, I rely upon it. It is submitted that the taxes due and payable under 1997 Act are on the use of the transport vehicle. It is submitted before, therefore, unless and until the transport vehicle possessed by the financier is put to use, there shall not be any liability of the financier to pay the tax. Then the next para. It is vehemently submitted by the learned counsel appearing on behalf of the appellant by relying upon section 4 within bracket 2A, section 6 and section 9, that the scheme of the Act emphasizes the operation of the vehicle, specifically a transport vehicle. It is submitted on the operation or use of a transport vehicle. Preliminary and additional tax is imposed on such a public transport vehicle. It is contended that it is for the reason both the operator and owner of the vehicle are included in the definition for payment of tax in addition to registered owner. Then it is urged therefore that the most important factor is operation or running of a vehicle as a precondition for imposition of tax. Now, Lordship, kindly come to then 4.5 and 5.3. Making the above submission and relying upon a decision of this court in state of Maharashtra versus Sundaram Finance, it is prayed to allow the present appellant to hold that appellant being a financier in possession of the transport vehicle is not liable to pay any tax under 1997 Act unless it is put to use. Then, my lord, kindly come to 8.9.
8.9, not there.
8, paragraph 8, sorry. Paragraph 8. Paragraph 8. চাপ চতুর্দিকে মামলার কোনটা ভালো করে পড়ি বলতো? Paragraph 8 is a very lengthy. Their taxing statutes mentioned therein. Then
they have been quoted.
Yes, quoted. My lord, kindly come to paragraph number 9. Paragraph number 9. On a conjoint reading of the aforesaid provision, have you also got it, my lord?
Yes.
On a conjoint reading of the aforesaid provisions, it can be seen that in respect of a transport vehicle, the tax is to be paid in advance as monthly tax or yearly tax, as the case may be, and only thereafter such vehicles shall be put to use. In our, my lord, the taxing statute also, it is stated the tax is to be paid in advance. Section 3 and Section 4 of this tax act statute says so. Tax shall be paid in advance. 9.1. Therefore, before any transport vehicle is put to use or used, the owner is liable to pay the tax in advance, and only thereafter the vehicle can be used or operated. The wording of Section 4(2)(a) are very clear. No public service vehicle shall be used in any public place unless a monthly tax at such rate is may be notified by the state government is paid in respect thereof. In our taxing statute also, it is said tax shall be paid in advance. Now, therefore, the requirement under law is to first pay the tax in advance as provided under Section 9 and thereafter to use the vehicle. In other words, it is pay the tax and use and not use and pay the tax. Very important, Lordship. First pay and then use. Therefore, the submission on behalf of the appellant financier that tax has to be paid at the time of use or thereafter cannot be accepted. If such a submission is accepted, in that case, section such and such which provides for the amount of tax to be paid in advance will become redundant and or nugatory. However, in a case where after the tax is paid, as per Section 4(2)(a), here after in terms of Section 4, Section 6, Section 7, the vehicle is not used and there is non-use of the vehicle, the operator and the owner, as the case may be, may apply and claim for refund as per Section 12 and may get the refund subject to fulfilling all the requirements as provided under Section 12. My lord, in our case also, my lord, the Section 21(2) is the, my lord, I think a refund provision is there. Yes, additional tax নেই তো এখন আমাদের ইস্যুটা। Lordship, kindly come to Section 21 of the Additional Tax and One-Time Tax Act. That provision is there. The caption is refund or remission of tax.
Yes.
Every person who is entitled to claim refund or additional tax under subsection 2 of Section 8 or lifetime tax or one-time tax under subsection 5 or 9b shall make such claim in plain paper to the taxing officer concerned. Such application shall be accompanied by supporting evidence to show that certificate of registration and tax token were surrendered or that the motor vehicle was permanently removed from West Bengal or on change of address. They have to satisfy that yes, the vehicle did not occupy the road. Then 2, subsection 2, where a taxing officer is satisfied that the certificate of registration and the tax token under Section 14 of the Act in respect of a motor vehicle has been surrendered or that a motor vehicle has not been used or kept for use for a complete calendar month, he shall, on claim by the owner of the motor vehicle, refund or remit for each such calendar month. That is, my lord, the proportionately refund should be there.
Yes.
That refund clause is there, and apart from that, my lord, there is a provision that Section 22, my lord, a provision for appeal is
But
also
this,
there.
this provision which was considered here is not in pari materia with the provision that has fallen for consideration before us. Counter signature or commencement of validity of the counter signature or synchronization.
No.
All these expressions were not there in that statute.
In that statute, no.
No.
No, 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 no. No, only thing is this, that so far that judgment I relied upon and pledged before your lordship in 2022 5 SCC, there was a provision and the Supreme Court says that yes, tax to be paid in advance. Here also this question comes because of the division bench judgment my learned friend relied upon, that there was no question of in advance on and from the date of putting signature or counter signature. Our case is that the date of when the counter signing is made or that particular date, that is not the relevant for the purpose of claiming tax under this act. Now it fell to our lordship on the last day that there is a division bench judgment. Is there any other judgment of any court? Well, I could not, my lord, find out anything 7 except this, where a similar taxing statute was under the scanner of the Supreme Court. And the Supreme Court says, yes, here also section 3 and section 4 says that tax should be paid in advance. Clearly said. Our case is that my lord, considering that Supreme Court judgment, though it was under the, my lord, the UP Tax Act, Motor Vehicle One Time and Additional Tax Act, but the issue and or the language of both the statutes are almost same. Almost
so
same
far
in
as the
that they
taxing
are
act is concerned, but not the counter signature part.
no. The question is this, whether it is a taxing statute, and it was whether it was a taxing. Both are taxing statute. Whether it appeared from that statute that tax advance, that the road tax or any tax, additional tax, is to be paid in advance. Here there was a provision. Here in our case also there is a provision, tax is to be paid in advance. Then the question is that what Supreme Court said, that irrespective of the fact that you enjoy it or not, you use the road or not, maybe the vehicle kept idle, but you paid advance, then what is your remedy? First, pay advance in terms of statute. This is my contention. If the statute say that you pay advance, you have to pay advance. And then there is a provision for your refund for that particular period if you satisfy the authority that my vehicle did not ply on that during that particular period. Because here the question is, my lord, that whether there is any, my lord, the escape route from that division bench judgment. First of all, division bench did not consider this Motor Vehicles Act section 81(1) proviso.
But that will be going in the line of per incurium, which I cannot do.
Well, I am not. I know that. That is why on the very first day, my lord, I did not invite your lordship to that extent. To that extent. Now, at one point of time, well, I can remember at one point of time in my early stages, there was that, yes, we can say that, yes, this judgment is not applicable.
If it was single bench, I could have said that. But for division bench, I cannot. Per incurium for division bench,
incurium,
it will be
yes.
Beyond.
Because there are several judgments of the Honorable Supreme Court that
you are
rightly or wrongly, whatever the order passed, that is binding.
A division bench,
because that is the discipline.
A division bench can say that another
division bench can say that either per incurium or can refer the matter.
Similarly,
whether per incurium or refer.
Similarly,
in
if
both cases,
coordinate bench can always say per incurium or refer.
Yes, yes.
But for likewise for a division bench also, to say that a Supreme Court judgment is not binding because it is per incurium.
I have interacted with the Supreme Court judgment where Supreme Court say that one single bench of one high court, not our high court, referred the matter to the special bench, ignoring the division bench judgment.
No, that is
Supreme Court said how. this should not be the.
Supreme Court can say that it is per inquiry.
Yes, yes. No, another other division bench can also say.
Yes, division bench. See, equal strength. Yes.
Equal strength. Now, my only contention is that my lord kindly record our submission.
I'll record that.
That.
Yes, Mr. Bhattacharya.
Yes, my first submission would be that section, as Mr. Sen raised a question of repugnancy in between section 81 and section 7 of the motor, section 81 of the Motor Vehicles Act and section 6 of Taxation Act. Well, section 81 only relates to grant of permit. Only relates to grant of permit.
Grant of permit.
Renewal of permit. Section 81. And there is no such provision in the Motor Vehicles Act.
Almost, my lord, the gist of my submission is reflected in my report also.
My lord, there is no such provision in the Motor Vehicles Act regarding, my lord, realization of tax. Regarding realization of tax, state legislature has enacted the Additional Tax Act 1989 for realizing additional tax from the vehicle registered outside and used in West Bengal by way of interstate permit. Now, my lord, first of all, but there is no question of repugnancy in between section 81 and, my lord, section 77 of Taxation Act.
No, he is not saying that there is repugnancy. He is saying that section 7 and section 88(1) have to be read together. And if you see what his submission was, section 7 says about validity of commencement.
Validity of commencement.
Validity of the commencement of counter signature.
Commencement
of counter signature.
Regarding realization of tax.
Yes, and he says that the validity of counter signature will commence from the date of the validity of the permit.
Yes.
They are synchronizing with each other in terms of section 88(1). Therefore, section 88(1) and section 7 and 6 have to be read together. They form a complete code. That is what is submitted.
It is not that. Since when section 81 reflects in the permit. You also kindly have a look at the permit.
Yes.
Following section 81, the permit has been issued in favor of the petitioner by the STA Jharkhand. Well, page 21.
Page 21.
From 20/01/2024 to 19/1/2029. That is for 5 years. So section 81 reflects in the permit itself. Now, my lord, I am showing the judgment that section 81 has no relation with the realization of the permit tax under section 7. 2022.
Yes.
Yes, well. SC 009. SC 9. Supreme SC.
Oh, Supreme.
Similar issue, my lord, has been discussed in this matter, my lord. Though is 009.
SCCK, it is courtkachari.com. Yes. Paragraph.
My lord, your lordship, can you paragraph 11. But paragraph 10 first, my lord. In substance, the High Court has noted that the permit holders were neither disputing their obligation to pay vehicle tax under the 1976 Act and 1985 Act, nor are they denying the obligation to pay contribution towards the welfare fund. But it is neither a case of levy of tax nor permitted under the 1988 Act, nor deviating from the spirit of the said Act, which clearly predicates that for grant of discourage permit, the regional transport authority is obliged to consider the satisfactory performance of the applicant as a discourage operator, including payment of tax by the applicant. The provisions in the state legislation is not to suspend the permit issued under the 1980 Act, but the expression ineffective ought to be construed as enabling the permit holder to avail of the permit only upon payment of vehicle tax under the 1976 Act, as evidence of tax. Paragraph 11. The appellants have assailed the view taken by the High Court. It is urged by Mr. K. Parameswar, learned counsel appearing for the appellants, that the central legislation, the 1980 Act, occupies the entire fields of permits, and the said legislation is a self-contained code as expounded by this court in Hardev Motor Transport versus State of MP 2006. He would submit that the Chapter 5 of the 1988 Act deals with all aspects of permits, including their issuance, effectiveness, duration of validity, renewal, transfer, and penal consequence for any breach of condition. Section 81(1) of the 1988 Act envisages that the permit issued by the competent authority shall be effective from the date of issuance or renewal thereof for a period of 5 years. Once such permit is issued, the same cannot be interdicted by a state legislation during its validity period. Section 82 need not be valid. Next paragraph. In other words, there is an inbuilt mechanism in the 1980 Act for situation to deal with the violation of conditional permit or using the vehicle without the valid permit, or using the vehicle without a valid permit. This being a complete code, it would not be open to the state legislation to impinge upon the occupation field. Hence, Section 15 of the 1966 is a direct conflict with the legislative scheme under the central legislation dealing on vehicles and cannot transcend on matters relating to permits or its effectiveness during the term of 5 years provided for under Section 81 of the 1987. Whereas Section 15, but in my case, my lord, Section 7, Section 15 of the NSA renders a transport permit effective. Thus, it exposes the permit holder to multiple punishment under the 1988 Act. Now, my lord, you lost it. Here, my lord, Section 81 has been elaborated in paragraph 11. Paragraph 24. Next. It is a different matter that precondition of production of proof of payment of dues under the 1985 Act has been provided for before accepting the vehicle tax by the taxation officer. If so understood, Section 15 of 1966 cannot be regarded as in conflict or repugnant with Section 81 of the 1980 Act. Even under the 1980 Act, the permit holder is obliged to pay tax regularly, failing which it can entail cancellation or rejection of permit renewal, including penal consequence for violation. Now, paragraph 20. Coming to the challenge to the amended provision by state legislation in 2005, it is that the Parliament has not enacted any law regarding levy of tax on motor vehicles. The 1980 Act does not deal with levy of tax on motor vehicles and the consequence of non-payment of such tax, whereas the 1976 Act, hereby the 1989 Act, has been enacted with the state legislature under NT 57 of list 2 of the 7th schedule to the Constitution, which is exclusively within the domain of the state legislature. The reasoning regarding payment of tax in respect of motor vehicles and the consequence of non-payment are therefore exclusive of the 1976 Act.
This was in the context of a challenge thrown that the provisions are repugnant. That is not the question here. It is not argued that the provisions are repugnant. Rather, he is arguing that both are in consonance with each other. One says that it will be payable upon the commencement of the validity of the counter signature, and the other says when the commencement takes place. When is the commencement? When does the validity commence? That is his submission. There is no question of repugnance.
Judgment, it has been clearly envisaged that the section 81 only relating to grant of permit. Renewal of permit.
Mr. Bhattacharya, if Motor Vehicles Act was absolutely unnecessary for consideration, then in the division bench judgment which you cited also, section 88 could not have been considered. That is also of Motor Vehicles Act. So you cannot say that Motor Vehicles Act is absolutely out of the zone of consideration. Motor Vehicles Act will be considered definitely, because otherwise how will the vehicle be taxed?
In paragraph 28, last three lines, paragraph
Yes.
28. But if I not so wrong.
Yes, yes.
If so understood, there is no conflict between the period prescribed in terms of section 81 of the 1988 Act and the provision in the state legislation, be it the 1970. So there is no conflict, sir.
Very well. He is also saying that only, that there is no conflict.
There is no conflict, sir. So I have to pay tax first moment my
Counter
permit
signature is done. That was your submission. That was there from the very beginning.
Only for use of vehicle. On the issue of the use of vehicle,
that is not germane now. Use of vehicle is not in question, because he has not said that.
I cannot use my vehicle in the state of West Bengal.
Acha, for
unless,
that.
Unless the
Yes.
permit is countersigned. Another value loss. Paragraph 26 is paragraph 34. Paragraph 34. It is my understanding.
Yes. Yes, paragraph 34.
34. Next page. The authority, while considering an application for grant of a state schedule, is obliged to have regard to the object of the Act, including about the satisfactory performance of the applicant's state schedule operator and payment of tax. The other relevant provision for considering the subject matter of this bill is section 81, dealing with duration and renewal of permits. It postulates that the permit issued by the authority under the Act shall be effective from the date of issuance of renewal thereof for a period of 5 years. That has been made in my permit. The provision to subsection 1 envisages that where the permit is countersigned under subsection 1 of section 81, such countersignatures shall remain effective without renewal for such period so as to synchronize with the validity of the permit. We are not concerned with the effect of the provision in the present case. The relevant subsection dealing with the power of the authority to reject an application for the renewal of a permit is subsection 4 of section 81. It provides for the grounds on which the renewal of a permit can be rejected. The same includes plying any vehicle without payment of tax due on such vehicles and on any other. Besides this provision, there is nothing in the 1980 Act to deal with the manner of levy of vehicle tax or the collection thereof. In other words, the law made by the Parliament does not occupy the field of manner of levy of vehicle tax and collection thereof. If so, it is not possible to hold that there is direct conflict between the two provisions, namely in the law made by the Parliament and by the state legislature. Furthermore, on analyzing the legislative intent and the effects of the input provisions enacted by the state legislature concerning the manner of levy of vehicle tax and collection thereof, it will be amply clear that obedience to each of the laws is possible without disobeying the other. We shall elaborate on this aspect while dealing with the effects of the law made by the state legislature a little later. Suffice is to observe that the argument regarding repugnancy is devoid of merit. The judgment, my lord, 1981, 1981 AIR, Supreme Court, 774. AIR, 1981 AIR, SC, 774. RS Sarkaria and no, Messrs. International Police Corporation versus State of Haryana. On Bihar Taxation. Earlier, Kerala Taxation Act, then Bihar Taxation Act. Page 8, paragraph 11. We are also opinion.
Just
We are also of opinion that no
paragraph.
Page number 8, paragraph 11, subpara 4. We are also of opinion that
Yes.
we are also of opinion that no interstate trade, commerce or intercourse tax is for purpose of trade and falls upon passengers and goods carried by motor vehicles in interstate. No doubt it falls upon passengers and goods proceeding to or from an interstate or it is limited only to the fair and trade procedure. Last page 17. Paragraph 17. Last page. Very important validation.
Yes.
Based on our judgment in state of Mysore and Sundaram Motors Private Limited AIR 1980 Supreme Court 14A, it was argued in some of the cases that where the motor vehicle merely passed through the state, no taxable event occurred, and therefore tax could not be levied. In the Motor Vehicle Taxation Acts of several states, the charging section generally runs as follows. There shall be levied and collected on all motor vehicles used or kept for use in the state a tax at the rate fixed by the state government. In those cases, the taxable event is keeping for use and alternatively user within the state. Once the motor vehicle is used within the state, the taxable event occurs. And the tax is that. The decision in the state of Mysore and Batu Sundaram Motor Private has no application in such cases, as already pointed by us, while dealing with a similar submission. So, my lord, tax is acceptable only when if the vehicle used or kept for use. Unless the vehicle is, my lord, section 88, my lord, clearly says, my lord, section 88. What? Section 81, except and maybe otherwise prescribed. A permit granted by the regional authority or state authority of any one region shall not be valid in any other region unless the permit has been countersigned. And the permit granted in any one state shall not be valid.
Where are you
in
reading?
Any other state.
Where are you reading?
Well, section 88, subsection 1. By the fourth line. And the permit granted in any one state shall not be valid in any other state unless countersigned by the state authority of that other state. So, unless my permit is countersigned my permit is not valid in that state. Next paragraph, 18. In some states, the Motor Vehicle Taxation Act provides for payment of tax in the event only a vehicle being kept for use in the state and provide for no other alternative taxable. In such cases, the principle of our decision in the state of vice versa may be affected. It will depend on an interpretation of the conditions of the relevant statute. But so, relevant statute of the Motor Vehicles Tax Act clearly interprets that I am liable to pay additional tax moment the permit is countersigned, so long it countersigns subsists or countersigns the commences. They have to give the validity to the permit as per section 81. They have to. But they can realize tax only moment the counter signature is made. That section 7 clearly says. And section 81 also clearly says that. So you have to give validity of the permit, validity of the counter signature from the date of the renewal till the expiry of the permit. When the law clear says that unless I ply my vehicle, I am able to ply my vehicle. Taxation on that vehicle cannot be realized.
Where is that section?
Section 88, section 7, madam.
Yes. Section 7.
Yes, ma'am. 89. Section 6, realization of additional tax, or section 7, computation of additional tax.
Yes, so it is not dependent on user. It says it will be paid in advance, in the sense that it will be payable to the authority concerned before the date on which it becomes payable. That is, before the date on which the validity of the counter signature commences. That is one way of the reading it.
Section 7. Section 6, my lord.
Section 6.
The additional tax leviable under section 4 shall be realized by the authority where, under any law for the time being in force, such authority has to countersign the permit. And in such case, the tax shall be leviable for the entire duration
for which the counter signature
subsists.
So now that is the problem. Only the saving grace is division bench, because section 88 says that the counter signature once done shall be valid for the entire period of the validity. So the counter signature will be there till the period of validity.
It has to be according to section 81.
Yes. And till the period of validity of the counter signature, you will be liable to pay tax. That is also read by section 6. So if you read together, you will have to pay for the entirety of it. That is the real meaning, plain meaning.
That is the date that is the date on which the validity of the counter signature commences.
Yes, so it commences on the date of the counter signature being done. Counter signature was done at the time of the issuance of the permit with the date of the validity stated there. So all the sections have to be read in a harmonious manner. Since division bench has interpreted it, my hands are tied.
No, only you're just kind of consider this aspect only. Unless I can use that. So that is the
user, no, it is not only use. It says use or kept for use.
Kept for use.
There is a distinction there. What happened was, suppose you have purchased the vehicle for being used in Kolkata, right? And in course of, and you have purchased it, say, in somewhere in Bihar. Now, in course of bringing it to Kolkata, you crossed one more state. For the period during which the vehicle crossed that state, you will not be liable to be taxed, because you had not purchased the vehicle for being used in Bihar or to be kept in use in Bihar, kept for use in Bihar. So for that purpose, that judgment is applicable, not for your purpose. Here, your vehicle, though not has been used, but it has been kept for use. Even if it is kept for use, without it being actually used, taxation will be there. That is the.
It cannot be kept for use. Well, since
Why
well,
not? If you have suppose I have purchased a vehicle, I have not plied it on road, I have kept it under lock and key at my home. Will I not be liable to pay tax?
in that case, my lord. But,
So-
but in this case, my lord, according to section 88, subsection 1, unless it is countersigned, I cannot.
Section 88, unless it is countersigned, will have to be read countersigned prior to renewal. That is the reading. Suppose counter signature has not been done at the time of the first issuance of permit itself. Then in that case, yes, you can say it has not been countersigned, there is no valid permit. So therefore, you are not liable to be taxed.
Every renewal is fresh permit. Every renewal is fresh permit.
No, for that, fresh permit for cases other than that which fall under section 81. For the purpose of taxation, it won't. Only saving grace, again I say, at the cost of repetition, is division bench, not the interpretation of this.
Very interesting matter and it is to be clear.
Clear, so my hands are tied. I'll have to go by what the division bench has said. Whatever may be my interpretation, that will not hold good.
Here, it will depend on an interpretation of the provision of the 11th statute.
Unreported.
Not reported. 1974 to
1974 statute তো অনেক পরে
1974 to 1974 to
এত খাটা
principal is here.
This is on what ground?
My lord, okay, use of name.
That is not required. Why are you citing on that? I mean, we are not going on user.
For my satisfaction. Paragraph 15 on.
Paragraph?
Paragraph 15.
Paragraph 15.
In the middle portion, my lord. In the middle portion, in this case, my lord, since the taxing statute, since in the middle portion, my lord, since the taxing statute is a regulatory or compensatory statute, it is contained in the provision of section 6B7 of the Taxation Act relates only to the actual use of the public road. Actual use of the public road.
Where are you reading? I have not been able to-
Paragraph 15, my lord, at the middle.
Paragraph
At the
15
middle point, my lord.
means what?
It starts from in this case, the state of Rajasthan, 1963, 1961 SCR, same, my lord.
In this case,
Since the taxing statute.
since the taxing statute.
Since the taxing statute is a regulatory or compensatory statute, it is contained in the provision of section 6B, 7, 9A of the Taxation Act relates only to the actual use of the public road. It is pointed out that section 6 of the Taxation Act does not place the burden of taxation on the registered owners of the motor vehicles.
That is their submission which has been recorded. This is not the finding of the court. This is submission. It is pointed out. That is submission. This is not binding. This is submission which has been recorded.
My lord, paragraph 16, my lord, it is also the solution of G.
That is also submission. Why are you showing arguments?
Paragraph 23.
Yes,
only for use on the roads.
that is very well.
Okay.
Anything else? Anything else?
My lord, all those judgments, my lord, are not applicable, first of all, because, my lord, after
I am reserving it because with so many judgments I'll deal with it.
my lord,
So you have cited
1981 SC is not because
one, two,
of-
three, 4 judgments you have cited in total. 1 division bench and
81 Supreme Court is not
Three
applicable.
Supreme.
Our statute comes, Motor Vehicle Act comes 88 and Taxing Statute 89. But this was not considered at all. So far, this new judgment might not have been relied upon and placed before Lordship. Not a single facts totally different, everything different. Now, the only thing, Lordship, kindly might take note of Section 4 and Section 5, subsection 4 of the Taxing Statute. And I'm very sorry, Mala, to say that it was my duty to bring it to Lordship's notice. Section 4 of the West Bengal Additional Tax and One-Time Tax Act.
Section 4.
My Lordship, kindly, Mother, Section 4.
Yes.
Mother, Section 4 speaks that payment of additional tax by owner of a motor vehicle registered in
I am
other
not
state.
disputing it.
Here, the registered in other state.
I am not
Now,
disputing it.
अरे भाई चुप करो ना एकटू. Every owner of a motor vehicle as described in Schedule 1 and registered in any state other than West Bengal and flying in West Bengal shall pay the additional tax at the rate specified. Then, my lord, Section 5, subsection 4. Section 5, subsection 4. The additional tax as leviable under Section 4 shall be realized by the permit issuing authority while granting the permit or area falling within West Bengal and endorse the fact having realized the due additional. That means permit issuing authority, it was his duty to realize the tax and pay it to me. And then,
But it never happens.
that means in advance. And again, subsection 3.
Here the issue
Section,
was the transaction and realization.
Section 5, subsection 3.
That is
Additional
not
tax
a
payable.
realization.
Arey baba, tumi chup karo na. Additional tax payable, subsection 3 of Section 5. Additional tax payable under Section 3 shall be paid for the year and in advance. Always in advance.
Yes.
And we are very careful. So.
রিজার্ভ হয়ে গেল হ্যাঁ কাজ বাড়লো না আগেরটাও হলো এটাও
মানে another thing মানে
হ্যাঁ এগুলো এখানে ডিল করলে পুরো 4:30 বেজে যাবে
মানে another thing is to be considered. They have computed the penalty by the cost. That they cannot do by the.
They have
মানে by call. Page 25
of
the liquidation by law.
page 25.
I am directed to request you to collect additional tax and MB tax in connection with the subject as mentioned above.
If you are not liable to pay tax, if that is the decision, then penalty also will go.
Yes, my lord.
But if it is held that you are liable to pay tax, then you will pay penalty also. I don't know what I will hold at the moment. Let us see.
Lordship, I'm appearing for respondent number 4.
In which matter?
Lordship, in this matter only.
We are from Jharkhand.
Jharkhand, your Lordship.
23.
23.
What is your submission? I did not hear you then.
Your Lordship, I have support the submission made by Mr. Senior Counsel Amar Sen, your Lordship, for the state.
You are supporting the state stand.
Yes,
Very
yes,
good.
Lordship.
ওনারটা সব ইয়ে নামটা রেকর্ড করে নেবে So I'll record that you are supporting the stand of the
Yes,
state.
yes, yes, your Lordship.
Very well. Yes. 24.
24 and 25 analogous.
25 and 26.
Not today. So 24, 25, 26, all not
They
today.
are totally exhausted, madam. So many matters in that building, this matter. So I thought, madam, kind.
All three matters not today. 24, 25, 26.
26 also.
He prayed for 26.
All the 26 time is
25 or 26.
all the 26.
It was same as 25, isn't it?
No.
Different.
I appear in 25.
24, 25, 24, 25 analogous matter.
Same.
Except resolution, everything.
26 time is.
Very good.
Well, I am for the
27 না এগুলো সব পাস্ট ওভার ছিল
yes.
আচ্ছা তাই বলুন
Well, 27 pass over.
27 was passed over your matter
Yes, Somnath.
হ্যাঁ তাহলে কল
আমি বলে নিব না পান্তুদা আছেন Mr. Devrai is here. All short matter, my lord was pleased to direct to submit one report in this matter. Whether the authority takes steps to declare vacancy, only this portion.
The report is ready. Oh. Then I'll hear it tomorrow. I'll hear it tomorrow because it will take time. With Mr. Bhattacharya's matter. If the same point is involved, then his matter will also be covered.
No, my lord. Here, my lord was pleased to direct the what steps the authority taken to publish this notification, and nothing more. My lord, kindly come to the order.
Notification was directed to be published.
Yes, please. My lord, kindly come to the order, my lord. Where it is listed.
File
Status report.
Yes, I've been.
But nothing more, my lord.
They have not made an application, an online application.
My lord, এটাই করলেন না তো
না এটা অন্য ম্যাটার দিয়েছে
24303
28 হচ্ছে তো হ্যাঁ রাখুন 28 কল হ্যাঁ না 28 is going on. You have created confusion. 28 কল করুন না not today থাকবে ওটা হ্যাঁ That is what I was also confused there. How come that is passed over? There was no passover.
Yes, my lord. My lord, I am appearing for the petition. I am being led by Mr. Jishnu Shah, who is appearing online. I am told, my lord.
Mr. Shah is left.
Yes, my lord. He has another prior commitment. My lord, all this, my lord, I'll address, my lord. I have taken instructions, my lord. Acha. Yes. My lord, till Mr. Shah joins, my lord, our instructions are, my lord, we don't stand in the way, my lord. A reason, daughter, my lord, the dispute here is really on account of silence on the part of the railways, my lord. My
That is
clients
why I
only
said that
appeared.
it can be disputed, but you kindly answer to his representation.
Only one thing.
Look, I don't find any representation.
No, it is several representations are there.
That is not about the irregularity in the.
So you address that because see.
On the circular. There is amendment in 22, then 24.
It's all
the allegation itself is because of the circular that if there is irregularity, then in that case it is because of the circular only that they are making those allegations.
So those allegations may be considered that I have no objection.
Only 131 Mr. Shah had made.
But not touching lot on the circular.
My lord, only 9. My lord, only one submission. My lord, I am sorry. My lord, only one submission Mr. Shah had pointed out. My lord, 131 of the writ petition, my lord, has seen. 131 is the last amendment. No, that is there. My lord, 131.
Amendment has been carried by calling meeting of all the records. There are altogether 1,000 records. So
very well. Then in that case,
page 28, 128. the meeting code of the all the stakeholders.
No,
I
one.
cannot pass any order for the
This-
amendment of the circular.
I am not seeking
No,
amendment.
I will not pass any
Yes.
order directing any amendment to be done.
My lord.
I will only say you consider the
My lord.
representations
I will.
and the latest amendment that you
Yes.
have carried
Yes.
out, that you abide by. You will follow that amendment, whatever is the
131,
latest
131.
amendment.
Which page?
131.
131.
Yes, that's the last amendment that's
Till
carried out.
such time that you
without
consider
prejudice
the
to that. Yes.
representation, at least this is the proposed amendment,
Yes.
the amendment at 131.
Lord, this
This is the amendment, my lord. It has been carried out.
have been approved by all the directors.
So you
Yes.
follow this. That
I
is what
follow, yes.
that is what I'm
That's
telling.
all. That's
Till such time that you are considering, it will be expected that this will be followed. This I will record.
Now this I think supersede all earlier amendment also.
Very well, but they want this to be considered. I am saying that this, because this,
127 followed by page 131. Both.
no, Mr. Tiwari, the submission of the petitioner is
Hmm.
that till the time the representations are considered in the interregnum, please ensure that the railways follow this circular at
Correct.
page 131. That is your circular. You have issued it, so you will definitely follow it.
My lord. Kindly note then direct note the executive director of freight marketing railway board.
Yes,
He will
and
consider.
where is the representation which you want to
Representation, my lord,
want the railways to
several,
consider?
my lord, the most comprehensive, perhaps, my lord. My lord, the entire writ petition can be treated to be a representation. The writ petition.
That is
Okay,
that order is
my lord,
it won't be in the fitness of things.
They have
because-
challenged the circular of 22.
no.
That is the only subject matter of writ petition.
20th February 24 is under challenge. My lord, just indicate.
And let them make a press petition. I will consider.
You want a fresh
That will be
representation? You
I
make
think
a
it
detailed
is better, my lord.
representation.
We'll make a fresh representation
Yes,
within a week.
and
my
I
lord.
will
think
hold
that's
that this will not be in derogation of the arbitration clause.
Malad, kindly do
my-
not provide for that.
my
Malad,
lord, my-
arbitration clause, kindly do not provide, then I'll be Malad, forced to go to arbitration in case Malad, I'm not.
No,
happy
will
with the
not.
decision.
I'll not force, but I will not do that away also by way of asking them to consider. So I'll say that this consideration will not be in derogation and will be without prejudice to the rights and contentions of both the parties.
No, that's right. Malad, kindly keep it at that. That will be enough.
No,
If your
because
lordship mentions-
because Mr. Saha, if I don't clarify that, the problem is then in that case it will mean as if the arbitration clause is also.
No, my lord. Your lordship is simply remanding the matter for consideration.
Yes,
My lord,
so
today if I
that
have
should
to
be.
come back before your lordship, that point of time, your lordship will consider.
In terms, then I'll say that in terms of the agreement, since there is already a provision for amicable resolution of the disputes, therefore that should be considered. That I'll say that will be better then without prejudice to the rights of and contentions of the parties, both in terms of the agreement as well as other remedies available in law. That I'll say. So both all the
Other
things will be
remedies
okay.
available in law, yes, that will take care.
Yes,
That
as
will take
both in terms of the agreements as well as other remedies available in law. I'll
Yes,
observe. I'll not shut out anything.
I'm
So that
grateful.
everything
I'm
is
grateful, my lord. I'm grateful.
Yes.
But your lordship will kindly provide that they will, my lord, now, my lord, at least in the interregnum comply with, my lord, the amendment number 6 dated 9th August or 9th September 2024.
That I'll say that it will be expected that during the time the representations are considered and the authorities come to a decision, they will abide by whatever is there in the 9th August 2024 letter.
I'm grateful.
That expectation I will record in the
I'm
order.
grateful, man. I'm grateful.
Because that is the latest, right?
Yes, that is the latest.
So I'll record that it is submitted that it is the latest, so that will be. Please correct me on the facts if I'm wrong.
Well, may I have your lordship's leave, my lord?
Yes, please.
I'm
Mr.
very
Shah.
grateful.
Thank you. The petitioner is aggrieved. ওইভাবেই করে দেবেন। এটা লিখে দেবেন যে it is agreed that that is the latest circular, so that
Obliged, deeply obliged.
I have recorded that because that is the latest circular that should go on record.
Deeply obliged.
Disposed of. Next.
Number 35.
What happened? Not today.
Went to the washroom.
Pass over করে দিন 36 পাস ওভার করুন, উনি আবার একটু
22nd or 23rd অত দিন কেন 10 দিন kindly make it only 1 week time but
আচ্ছা, I am giving you 1 week.
Yes.
Next Wednesday you file it.
yes
Next Wednesday you file. 1 week. লিখে নিন, একটু লিখে নিন, অর্ডার একটা লিখে নিন 36 হ্যাঁ।
P5 my lord
35 কল করে দিন, পাস্ট ওভার এর আগেরটা।
the petitioner applied for a permit, interstate permit for an interstate route Tata to Kuinapa. My lord, page 24, it has been supported with a representation, my lord, page 22.
Page 24, yes.
Is the application along with fees, my lord, page 26. And my lord, it is supported with a representation, page 22. Well, let it be considered, my lord, since my lord, STA Jharkhand has issued permit on this particular route in favor of this, in favor of one operator of the state of Jharkhand, that is my lord, page 17.
Yes, Mr. Devre, consider it and dispose of.
My lord, page 17, my lord, similar permit has been issued by the STA Jharkhand.
The petitioner is a
I let you.
you file a supplementary affidavit with the prayer because it will be a difficult order then. On what basis will I pass the order? There has to be a basis to the order.
Sorry, madam.
as prayed for. (23rd). না এটা 37 কি কল হবে? 78 থেকে কল হবে, তাই তো বলছি। 78 থেকে কল হবে। থ্যাংক ইউ। No, 78 onwards. You have missed the bus. Those who have missed the bus will get it after the journey is complete. Because what happened was, I was calling same matters every day. Every day somebody was taking time them from the first matter, so I decided that whoever will miss the opportunity will get the opportunity after completion of the list.
Rita Dasgupta. There are affidavit of service. I will also sharp a copy.
You are appearing for the petitioner. This side. You please come this side.
This is a matter relating to interest on gratuity.
Whom have you served notice on? You serve notice on the GP's office. This notice will not do.
Affidavit service is also there.
That is of 2022. So long time has passed.
Long ago.
Since the matter,
Lordship, I have also served. I am the petitioner, with Mr. Das. I have also served upon the concerned state advocate. He has received the same.
Who is appearing for the petitioner?
I'm sorry, he is my junior, my lord. I am sorry to say, see, on the same time in which I am appearing before your lordship, then why my junior has been entertained
That
to
you
move
sort
it?
out. That you sort out.
This is very bad.
That you sort out. You tell him out of court.
All right.
Since the matter pertains to the year 2022, the petitioner shall serve a notice on the office of the learned government pleader, intimating the learned government pleader that the matter shall be taken up next on July 23, 2025. Affidavit of service direction. Yes.
Yes, 79, my lord, this is the current notice upon the learned government pleader who is appearing in this matter. Tuli Sina. My lord, affidavit of service is there. 79.
Serve on the office of the government pleader. This will not do because I don't know who
Police
this
Sinha is also appointed on behalf of the
So you, if you
state.
can bring him, I'm passing it over. Bring him, because otherwise, in their absence, I will not dispose of any matter. You bring them. If both parties are there, I will hear and dispose.
On 23 matter the self matter.
Very well. वही same order ta
Same
record
order
करो. Same order. Any ex party orders, I don't want to pass.
Affidavit to service I will file, that will be kept to their record, I think.
ওই affidavit of service টা ফেরত দিয়ে দিন।
Affidavit service, affidavit service.
দুটোই চিঠি আর affidavit service দুটোই। নাম দিন। Please give your name. এইটি চলো নট টুডে করুন। হ্যাঁ কেউ নেই যখন আর কি করবো, ওরা তো পরে তারপর থেকে কল হবে, অসুবিধা কি আছে?
Upon instruction, my lord, I'm praying for not today, my lord.
Not today. Not today, don't pray. It will automatically be not today, but you will not get this opportunity tomorrow. Tomorrow it will not be called. Pass over করে রাখো। হ্যাঁ না থাকলেই না।
Your Lordship, Mr. Ujjwal Rai is appearing for the petitioner. I am only praying for a short passover, Your Lordship. Your Honor, this is my first time, so I don't know if
Yes, please. What is the matter?
Yeah, yes. It's about interest on gratuity and the gratuity and pay.
Take it easy. We all had a first time, not a problem at all.
Gratuity and arrear pension and pension.
Right. You have been paid. You are being paid pension. You are receiving pension.
Yes, I have received pension.
They have paid it belatedly.
Belatedly. There's 15
How many days delay or how many years delay was there?
15 months delay.
15 months.
15 months delay was there.
There is nobody appearing. You serve a notice again and come. I'm recording that.
Okay. Thank you, madam.
The petitioner
Your Lordship, take item 81 passed over.
passed over no. Later on.
ठीक है तो आप both side.
You are there. All the sites are there.
No. There was a
Then
direction of your lordship, returnable, made returnable as served, affidavit is complete.
let us see. Maybe in the meantime they come.
Very good.
Yes, chalo.
Your lordship, my learned senior, Mr. Ujjwal Rai is appeared.
Passed
He's
over.
on lake. Great.
Fast over. Yes.
Last operation, the strictness letter by
Petitioner is not there. Passed over. Not today. You are ready with the report?
is ready.
দেখি রিপোর্টটা রেকর্ডে নিয়ে নি, ওটা রেকর্ড করে নি, দেখি ফাইলটা দিন।
There is no improvement in the status of the application.
Very well, he is not there. লিখে নিন, learned advocate appearing for the state.
Well, I'm waiting for the petition. And in last occasion, it also is directed to serve all parties. Serve the court, serve.
Nobody is appearing.
Serve everybody. School, it also is directed to serve school specifically. Serve school.
Kanak Kiran Bandyopadhyay, he is regular, he appears. I'm passing it over, see if the state comes. এটা ফেরত দিয়ে দিন, certificate of service.
After the also is directed to serve the school authority.
Why state is unrepresented everywhere today? Is the difficulty. In the last occasion they were there.
School is not there, for that reason the lordship is directed to serve a copy to the school.
You were there?
My learned senior is on her leg. Courtroom number 16.
Which matter? 91?
81.
91 is going on. What to do? Passing it over because I don't want to pass ex parte orders.
My lord, one thing, my lord, 85, I am for the petitioner, my lord, I am coming. My lord, in this matter, I want to, petitioner is directed to non-prosecute the matter.
You have your letter?
No, my lord, letter is.
If you bring your letter, I'll pass.
Great. Pass on.
First.
Your Lordship, Mr. Rai, sir.
Not today.
Your Lordship, pass over.
Yes, but nobody is there. Passed over.
And for the petitioner, Lordship, last occasion directed
95, 96.
directed my lord to serve a notice to the school authority and also state responsibility. I already
What is the matter?
transfer of single teacher.
Oh. Pass over. Let us see if they come, because suddenly list has collapsed, so they may not be available.
Last occasion, Mr. Mitro, Saurav Mitro had appeared on behalf of the SSC.
97 out of the petitioner, this is one single teacher. Lordship has one passed in my case, one.
Please let us say I will not pass any ex parte order. Let people come, because see, if list collapses, we on that side I have faced problems. It becomes difficult for people to understand. Suddenly,
Okay.
chalo.
This is one of the third time, despite one of the notice. Pursuant to Lordship direction, I have given a notice. So one of the very well, this is today, not today.
Why don't you call them? Make a phone call. Call them. Say matter is being called on.
Difficulty is that if I am called, they will not bother to receive this call. And also because
98 চলছে জানি সেটা জানি ভাই
with that as it may not
Passing it over for the time.
pass over for the day man.
If you don't want, it will be passable for the
No,
time. Take only those matters
no, but-
where all the parties are there. Because at this distance, it is already 4:07. So 25 minutes taking matters ex parte does not augur well. If it had been the first hour of the court, then in that case, yes, I could have considered. Not now.
Very pass it over. In the meantime,
Yes, yes. If you can bring your other side, I'll definitely take up. I'm
Well,
here to take up.
well.
Bring your other side, I'll take up.
Well.
If all sides are there, I will take up.
Appearing for Mr. Shantanu Kumar Mitra is appearing.
98 or which one?
Lordship.
Which item?
Lordship 98. Mr. Shantanu Kumar Mitra is
So
appearing
others,
for.
petitioner is not there. When you are there, petitioner is not there. Petitioner is there, you are not there. Chalo, call korun next.
For the petitioner. Mr. Mitro is there. I have informed him, but oito. Fortunate today. Hey, report is there was a direction to file a report or take instruction regarding one issue that I have opted 3 schools at the time of making application. But my first choice, although there is a vacancy, the authority recommended my name in the second school.
You are supposed to take instruction as regards his
That
representation.
direction was there. And yesterday also I told Mr. Mitro, what is the news regarding update?
Why, madam? Take the, because it's pending at your end, West Bengal Central School Service Commission. One more week. This is of June, 1 month already gone. Today is exactly 1 month. Learned advocate appearing for
a single teacher. Single teacher.
Same, single teacher. Why are they not appearing? Matters are done if they appear. Juliet, chalo, next.
I'm for the state respondent.
Allow for the petitioner.
Yes. Finally, somebody has come. You're for the state or commission?
State.
And commission?
Commission is not present, again.
Commission service done?
Yes. Yes.
Anybody appearing for commission?
Let's see your lordship.
Page 51, Millard. If your lordship Millard turns to page 51, Millard. Single teacher.
Single teacher is not a ground.
Not lordship judgment in case of my case, my lord. No, no, no. May I hand over? Considering the division bench judgment, two division bench, lordship has passed. I have to copy them. I think also.
You have the copy of this?
Size করে রেখেছি। দেখছি। এখন এই যে তুমি may I hand over the separate copy for your lordship?
এটা ওনাকে দিই। ওইটা দিন আমাকে। লিখুন।
Lordship, I am for respondent number 9 and 10, ad hoc committee of the school.
I am for the petitioner. Petition.
Yes.
Lordship, kindly, Lordship, kept in record my instruction, that is, Lordship, as per my instruction, Lordship, at that time, 2/5/2022, Lordship, the ad hoc committee, Lordship, not issuing the NOC, Lordship, because, Lordship, at that time, there are 3 assistant teachers and no group D staff was there, Lordship.
Petitioner is a group D staff.
But now,
Petitioner is a group D staff.
yes. That time petitioner
Yes,
is
Mr.
one of the group
Bandyopadhyay,
staff.
so many matters adjourned because of your absence. All matters. The earlier matter was also yours. Mr. Panda's matter was there.
Lordship.
He's there. To call him if he's there, I can dispose that of. Surely. You are not there. 102?
112.
Yes.
Lordship, at that time, Lordship, there was no group, another one group D staff except the petitioner, Lordship. So, Lordship, they rejected. So, Lordship, they are not issuing the NOC, Lordship. But now, Lordship, the position is there are 4 assistant teachers and 1 group D staff is there, Lordship. So now they can consider, Lordship.
To forward the application then, what is the difficulty now?
Difficulty is now portal is off. Because that is online application.
So you make a fresh application?
Directed, I make a fresh
You make a fresh application, you take steps in accordance with law?
But that application is pending. Portal is closed. Yes, yes, yes.
Forward the application.
All the authorities are for take action in accordance with law. Now fresh application are
Before the school only.
School, that is not head of the institution, that is HOI, it's not. He will forward it to
The petitioner 8 September.
আমার তো একটু আগে।
In respect of teacher, non-teaching staff both. Teacher will be bigger in the respect of functionary, but non-teaching staff still now not having. That is the position. Yes. Thank you.
Six G, you said.
6G or something.
Yes, 6C. If resultant vacancy of school in particular subject becomes 0. No, if it is about subject, then group D staff will not be related to any subject. Group D staff will not be related to any subject. It says consider the number of subject teachers and roll strength if resultant vacancy of school in particular subject becomes 0 or not commensurate with roll strength. Then the authority of SMC shall not forward the application. Therefore, it will not apply to group D. So therefore, this single post should also be only in respect of teachers. That can't be in respect of group D staff. No, it's there before me. I'm seeing that. No, it speaks about subject. Subject teacher will not include group D staff. Group D will not be related to any subject.
Yeah,
Group D will not be related to any subject.
Yes, yes, yes.
But I am also handicapped today. I don't have the copy of it.
So why you have not come prepared? You should have come prepared. Then you take this back, you file it on another day.
90 in respect of 90.
I am making it not today only then. So should not today for a third. Yeah.
Not this week.
Not today will mean not this week.
Lordship, kindly keep it next week, Lordship. Kindly, Lordship.
Very well. I am making it
Next
not
week
today. Not today means not.
Not this.
Huh.
So no order to.
You read your instruction before making submission. Otherwise, you will be in difficulty someday. Something will be recorded, then
No order.
no order. Rightly done, because for you other 4 matters were adjourned.
I don't mind.
So you should not be given.
I'm extremely sorry.
So God is kind. You deprived others. So for you, many people could not earn.
Yes, we have
So
suffered.
for you could not earn now.
Justice done.
Thank you.